All right, yo, swoosh. I want to say thank you. I asked you earlier in your chat. I was at work. I want to restream this shit. Not as an insult to you, but in case Tyra gets your channel, at least you always have it back up on my shit. You already said the fuck. Which one is playing? That's on my Bluetooth playing. I got Tyra playing on goddamn like 5 different devices right now. All right, so what I'm gonna do is I am going to let this play. Swoosh, thanks. Ain't got no cash app, and I'm part of Buffalo, New York, but I'm gonna find a way. I'm gonna hit John Goodwill up and get him to send something real quick. Thank you, Swoosh. Should be playing now. Audio check, audio check. Let me turn off the camera so I can do an audio check. There we go.
Recorded live.
Good evening. It's True Freeman 317. Today is January 15th of 2015. Decided to do a spur of the moment call today. Want to kind of make up for the Monday show being, we had some buttholes, that I had to discuss that I will be addressing here in the near future. Not even going to get into that, you know. But I have some things I want to discuss today, as well as I believe that someone's going to come in and because I really don't know what really transpired. But one was able to get their case dismissed and dismissed the right way, from what I'm understanding. And that's why I titled the show Dismissal. What did I title the show? Let me pull it up. Where is that? I have all this stuff pulled up and on a couple computers. No, I got it here somewhere. There you go. That's why I titled the call. The topic of the day is, titled, today I will discuss what it means when a case is dismissed with prejudice, and dismissed without prejudice. I will also be discussing a few other things, and I expect someone that had a case dismissed will be calling in to share some of what happened. Hope you can chime in. Now, a few text messages were sent to me in regards to it, and this is someone that, appeared on my call quite a few times. Was a caller that supports the show and calls in, from time to time. She's been missing in action. I guess she's still getting it in. So, since she was free today, I decided to go ahead and open up the call and, discuss some of this, as well as give her an opportunity to let me know what happened, as well as the rest of you. You're going to find out when I find out. But it just made me, hold on for a second. Turn this volume down on this phone because I know it's going to get the acting crazy here shortly. At least a little bit. Definitely not too much paying attention to it. But I'm going to discuss some things, and you're more than welcome to chime in and add to the call, or if you have any questions, if I can, by chance, answer it or guide you into, the direction you're looking to go, I'll do that. I want to go over the difference between, the different types of dismissal, because people have to understand this, because when cases are dismissed, whether it's dismissed against the plaintiff or the alleged defendant, you have to understand what type of what dismissal does that case fall into, what category does the dismissal of the case fall into. So you want to understand the difference between dismissed with prejudice or dismissed without prejudice, because a lot of people, even when you are defending yourself and you file for a motion to dismiss, you don't even stipulate which type of dismissal you're looking for. And just because a case is dismissed does not necessarily mean that it is done away with. And this is why I told people, I've been telling people, about this, but just not in this way that I'm going to go over tonight. But To dismiss a case does not mean necessarily that that case is destroyed, that that case has been dissolved. And you need to really clearly understand the difference between a case being dismissed with prejudice versus a case being dismissed without prejudice. So I'm not going to be on long tonight, but I'm going to go over this real quickly. And I think that she's in the chat. She's on the call, so I'll be with that sir once I get through. I'm doing my little thing. I'll bring her in so she can let me know as well as you all, without. Because like I said, we just text back and forth. She let me know the day that I guess the case was today, so this took place today, and I'd like to hear about it. And at the same time, hell, why not let you all hear about it as well? I don't know how many of you came in the beginning when I logged in. Sorry about that. When I logged in, the chat is always open 15 minutes before the show starts. Yeah, one of the trolls in there, which I'm not going to, get into too much about them because all they do is run. Because as soon as he saw me log in, he cut out. But just to show you how these people talk me, and they just come in. The show hadn't even started. Music playing or nothing.
Wait, did I hear something about trolls? I think I heard trolls. 2015. We won't with that shit yet. So
you always come into my chat and try to just do childish things, and this is just some of the bull crap that goes on, which people that know how to get a copy of the chat after the show, everybody will be able to see what is transpired, what has transpired during the show within the chat. So, his name is Puber T. He's been following me on YouTube. Everywhere I go, he's like a stalker, I'm not gonna get too much into that. I just want to just give you let you know down the comments and read through pretty much remarks that I get from these trolls and agents and stalkers. My information is like that. Why don't you, or it's not good or whatever it is, won't you call in and address me like a man and stop acting like a child? We can get on the line and debate each other with factual information or hearsay and get exposed or do the exposing online like two adults, whether it be a woman on the other end or a man on the other, and it really doesn't make a difference. So you guys be acting as childish as you do, and you're not man or woman enough to pick up the phone and dial in and talk to someone on the air live, it goes to show who you really are. I call you internet gangsters or keyboard gangsters, because that's what you are. All you do is sit behind a computer screen in front of a keyboard and type all this garbage when in fact you're compensating for the lack of something. Because it doesn't make any sense, and I cannot begin to understand why you guys spend so much time following me and putting out this false information and so-called try to expose me. You've been doing it for too many years, and you still have yet to expose the one thing. So evidently you're being paid to do what you're doing. I hope you're getting enough for selling your soul, and I'm just going to leave that with that and go ahead and read these ridiculous comments. It says, where is that little solid-off midget nigger at? Why is he not here blowing more smoke up your ass? The biggest little midget bull shitter there ever was. And then he says, bet he takes it up their ass too. And it's like, it's funny how you guys make these gay accusations against a lot of different people. The fact of the matter is, the majority of you that do that, maybe possibly that's what you are. I'm confident in who I am. Just if something comes out your mouth and you say it about me, that does not make it true. And it's funny that you would go to, you would stoop to a level that low to continue to do what you do on a regular basis. I suggest you get a real job.
True. They've been thinking you was Yag since 2015, and you're not even saying a lot of gay stuff. So,
And do something with your life because you're just showing who you really are. Now, with that said, let me go ahead and give a shout out to the people in the chat. Maybe he's one of these guests in here because I blocked his puberty ID from chatting things. He'll probably create another one. The minute I see something, let me know. If someone sees it, just if you're in the chat, just type in the chat. And if I haven't blocked them yet, just keep hitting it. I'll look over because I got two things pulled up here, so I'm trying to get this more organized. And I'll get them blocked so we can continue without. Of course, we're gonna get some distractions, but I'm, in 2015, getting geared towards not allowing these people to distract me. I'll give them a couple minutes if they think that's very important to address how ignorant and ridiculous they really are, while keeping it professional at the same time if I can, or keeping it rated PG, so to speak. But it is what it is, because they know who they are, but it is what it is. Let me give a shout out to Guest 7, Guest 8, Guest 9, Southwest Florida, and 2 West Oklahomas, and I'm assuming one, maybe even both, are connected to each other. We shall see here shortly. I just want to get a little bit of discussion going on about the differences in regards to a dismissal. Now, if I go to I'm not going to go through 40 dictionaries to give you guys definitions of words. But what I will do is attempt to give you a decent breakdown so that you will be able to understand you will be able to comprehend if you are filing for a dismissal or if a case is in fact dismissed against you. You understand what type of this, what the specific dismissal being the type that it was, what it actually in fact means. Trying to just figure out the best way to explain it so you guys got the skills. We're coming out of the judicial and statutory definitions of words and phrases, which I highly suggested everyone check that out. Oh, before I get to that, I posted this. I posted in the chat earlier. Sometime when you guys come in, I noticed some of you say that the chat, if I say I posted something in the chat, some of you are not able to get and or access that for some reason. So what I'm going to do, since we have a few people in, and when I posted that, I was the only one in the chat because, puberty saw me come in and immediately logged out, because they run like little scared little, just little scared little people. I'm not going to go in on them like that. They know what they are. Just, the people are seeing that as well. But I'm going to post my information that I want to share with you all. Some of you may not have been following me, and some of you may have been following me in a while, and some of you may have been on my Facebook, and you probably may notice that I'm not on Facebook anymore. Will not be. So I'm going to post some of my new forms of contact information in the chat for you again. So what I'm posting right now is my email, which you all pretty much know my email. Some of you don't, but I also have went over to the unseen.is email server, and my email address is truefreeman@unseen.is. So I posted that in the chat, and I still have the straightexposing.com, but you have to have backup. And as well as the unseen.com is tied to my new website that I just put online the other day. I've been working on it for a couple of weeks, so I'm going to post videos shortly too, and you guys will be able to have that. It's straightexposing.com. But I thought it was saying I was on Facebook. Now, what I just posted now is where I'm on, well, showing you how to create an account. I posted my true freeman and unseen.is information, email, and my thread exposing them. I also posted the Steam service itself, and you can create an account on Sing.is, which is a social platform like Facebook, and it's growing. You know, you could also create an email through unseen.is, and they're very secure. There's some videos that are going around online of the owners and why they moved to Iceland, and it's pretty much because Iceland is real strict with their privacy laws, which basically blocks um, a lot of people, even government officials, from accessing people's information and accounts without a valid warrant and actual probable cause. So, if I can, for the shows over, I'll try to locate those videos and post them online so you can get an idea about what seen and unseen is. And you can hear it from the owner, and he's being questioned on certain things, and he breaks it down why he chose to do certain things. Okay. Yeah, I'm on my wife's website. I was checking something on my website. It's showing me live because I'm live. You guys will have to check out my website because I have this page called Live Broadcast. If you go to it right now, I have my Ustream, TalkShoe, and Livestream on there. So if I ever go live and someone just happens to click on my show, they'll see that I'm live on TalkShoe right now, Ustream or Livestream, whatever one it is, and they can listen to the show from the website, or they can click on the page and actually get directed to the TalkShoe by way of clicking the link so they can interact in the chat. I think I'll be putting the chat board inside the website as well, so they can just stay there and do everything there if that's what they want to do. But it's showing that I'm live right now on my website. But I just posted how you can create a site on Steam, or where you can create a site. I'm also on Weekly because YouTube has got its mess going on, although I'm still on YouTube, just not going to be putting, a whole lot of certain forms of information on there. But I also wanted to have a backup plan, and just like Sing.is, Weekly is new and it's growing 12. So Sing.is came out to counter Facebook, and Weekly TV came out to pretty much counter YouTube. Now, people may be saying that, well, Weekly TV is not like YouTube. Man, you can't do this, you can't do that. And they'll say, Sing.is is not like Facebook. You can't do this, you can't do that. Well, let's think about when Facebook and YouTube first came out. You could do a lot of the things that you do that until the demand for the use of their company or their services was known. They, it took time for them to upgrade. And by upgrade, you do it by way of demand. If people are not going over there signing up, trying these sites out, you're never going to give anyone else a chance. You see what I mean? Facebook and YouTube is getting old to me. I don't think they'll ever go away, but I think they'll be a thing of the past. Like MySpace, it hasn't went away, but it's a thing of the past. Same thing can happen with the rest, but at least we have to try other formats and avenues. In Weekly TV, as well as Sing.is and Unseen.is, they really have created these sites in order for people that come on, they're comfortable and confident that their information and things like that are going to be secure, and that they're not going to just be giving up your information to these government officials unlawfully for absolutely no reason, just because they want to spy on the government. So, we trying to pull out this mess. We have to gear towards that, and sometimes we have to. But I just posted my Weekly account. You can follow me on Weekly, weeklytv.com. course, most of you should already know my YouTube channel. But I'll go ahead and post that here. I'll go ahead and I'll post my website too, so those of you get a chance, appreciate you checking it out. Anyone wanting to acquire Dropbox access, there's a link in there for that, a gift link in there for that. There's a page in there that will take you to the gift link, and in regards to the Dropbox, you'll have access. For anyone who's interested in any of those previous webinars I did, the remittance webinar, the right to travel, and status correction. There's also a pay-per-view section in which you can go in there and do the same thing. There's also at the bottom of the page, as well as a linked page itself, and on the main menu, in case anyone just wants to support the cause and send gifts to Freeman. Now, I've never built the site before. I put this together in 2 weeks. I think I've done a decent job. Not knowing what the heck I was doing. So, I urge people to check that out. You trolls check it out too, because I'm stepping up my game. And I'm gonna have some things on there just to expose you too. I won't be doing these things on my show, but I'll have a section somewhere in there putting trolls on blast by name. That way people will know they have a YouTube channel or they have shows. They know to block you because they already know what type of people these are. I mean, they are. So there's no sense in having these people continue to trespass and bother the people who we're trying to further educate ourselves based on facts. So with that said, that's what it is. So if you get any time, free time, check out the website, follow me on Weekly. If you feel like you would like to create a email address on unseen.is, you can, but you don't have to. You still can email me from whatever address you got to truefreeman@unseen.is. But I think if you really do some research into it and check it out, I think you probably would like the fact that using unseen.is as an email server is a more secure way. It's the securest way out here now in regards to email. And I'll be doing some videos there in the future, putting them online as well, so that people can get my take on it, because I've been out there for quite some time. About a month now, I believe. So check that out. And with that said, I'm going to talk about this message. So looking into the judicial statutory definitions of words and phrases, which is in my Dropbox for those of you who have access, but also for those of you who don't, you can just Google or don't want to get to have access to the Dropbox. All you have to do is Google judicial and statutory definitions of words and phrases, and you will get it. You will have to download them, and you can get it that way. So it's a great read, great dictionary, because it pretty much describes how they construe words statutorily and judicially. And they give you many different definitions of the same word, or many different interpretations of the same word, depending on the circumstances. So, for the most part, so I suggest people really check that out. But it didn't have a lot on this mess, so it had some other sections in there, but I have to, well, it did have, a decent amount. So I'm just going to go over a few things in regards to that. And maybe in between, I'll do some explaining, in regards to, how I'm understanding it. So let's start with dismiss. It says the motion to dismiss. Dismiss is equivalent of cancel within the meaning of a contract to cancel a suit. And that, I believe, is Click versus Smith, Klitze versus Smith, 91 NE 748, 749, 46 Indiana APP 26. And going in this dictionary, I see they reference a lot of Indiana cases in here as well. This is not an Indiana dictionary either. I just find that ironic. So going to dismissal, it says the decree of dismissal, dismissal of the merit, dismissal without prejudice, the dismissal with C, dismissal with prejudice, and C, dismissal without prejudice. Reason for dismissal, C, reason. Dismissal is equivalent to cancel. Same case number I just, case reference I just gave. The dismissal of a count of the dismissal of a count of an information is not an amendment thereof, but it is in the nature of an election to proceed on the remaining counts. On Penal Code subsection 1019, providing that the plea of guilty puts in issue every material allegation of the information, the dismissal of one count after the plea is entered, leaving another count, the allegations of which are complete and independent of the dismissed count, does not leave the case without issues joined. People versus Daniels. Now, going into a few of the types of dismissals that it addressed in the beginning: decree of dismissal, dismissal of the merits, C, merits, dismissal without prejudice, C, without prejudice, reason for dismissal, C, reason, and then it goes on to tell you how dismissal is equivalent to cancel. But just because you cancel something doesn't mean that, like, because it's a contract, just because you cancel a contract doesn't mean that that contract cannot be, brought back up again or done with again. So you have to, it pretty much depends on what type of dismissal it is or what type of contract based on the agreements in the contract. But anyway, carrying on, dismissal. Though not a final determination of the controversy, and it is a final ending of the particular suit. Livingston versus New England Mortgage Security Company, and that is 91 SW 752, 753, 74, Arkansas 379, citing district. I think that would be district definitions of words. Dismiss page 364. Discontinuous, page 360, and non-suit, page 712. And this is out of the judicial and statutory definitions. Those of you like blacks and things like that, I'm gonna get you some explanation. I'm gonna break out some things out of that here too shortly. A dismissal under Kansas practice is a judicial act rather than an act of the party. Whether with prejudice or without prejudice, it is in the nature of a judgment, and a judgment with prejudice, not set aside or reversed, is a final disposition of the controversy. And that's Hargis, Hargis versus Robertson, 79, PAC, 119, 120, 70, Kansas, 589. A final decree or judgment, see also final decree or judgment. While a dismissal for want of prosecution terminates the suit, it does not end the controversy. It being in effect a final judgment for defendant, but not precluding plaintiff from bringing non-suit for the same cause. It's real. Sheridan Publishing Company versus Goodrich, 140 SW 629 630 159 MO APP 422, citing 3 words and phrases, page 2105. Now, even as in regards to a dismissal for non-suit would be equivalent to a dismissal with prejudice, or without prejudice, excuse me, because basically it dismisses the claim against the defendant, but it does not bar the plaintiff from refiling. That's what it boils down to, or initiating a case. That's why one needs to understand the difference between dismiss with prejudice and dismiss without prejudice, or a dismissal for non-suit, which ends up being equivalent to a dismissal with prejudice. A dismissal of a cause of warrant of prosecution, though not a final ending of the controversy, is a final ending of a particular suit. In effect, it is a final judgment for a defendant, though it is not. That's what I just read. Actually, they had it in here twice. That's why I was intending to skip that because they started addressing something else and then recited that. Under revised statute 1887, subsection 4823, providing that the dismissal of an appeal is in effect and affirmance of affirmance of judgment or order appealed from, unless the dismissal is expressly made without prejudice to another appeal. The dismissal of an appeal for failure to furnish it or failure to furnish an undertaking in an affirmance of the judgment from which the appeal was taken under the order of dismissal is expressly made without prejudice to another appeal. West versus Digert, DYG, G97 PHC 961 962 15 Idaho 350. I got to excuse me, I need to turn this camera out because I keep looking up bird getting thrown out, but I can't turn that out. That's coming up out of the judicial and statutory definitions of words and phrases, or meanings of words and phrases. Now I'm gonna get into Black's Law 8 because it's going to clarify. Well, not Black's Law 8. We'll always come out of Black's Law 8, Black's Law 6. You guys want me to pull up some more? I can do that too. And then but I don't think I have to. I just want people to understand because some people keep, well, I filed my motion to dismiss and the judge dismissed my motion. Well, in some cases, you didn't even enter in the motion to dismiss proper, nor did you submit a memorandum to support your motion to dismiss, nor did you state what type of dismissal you're looking for. Are you looking for a dismissal for non-suit? Are you looking for a dismissal with prejudice? Are you looking for a dismissal without prejudice? I mean, you have to know these things in order to be able to put in a proper dismissal according to your case. And some of you, even if you don't get a dismissal with prejudice, you get the dismissal without prejudice. And if they do bring it back up on you, you later on, at least you have time to get your stuff together so that you would be better prepared, maybe to, in fact, get it dismissed with prejudice the second one, or the next go round if there by chance is the next go round. Because it's no different than people saying, well, Jimbo got arrested for a shooting, man, but for a murder. He was down there for a week, or he was down there for 72 hours, and they released him and dismissed the charge. And it's like, first of all, you have to make sure that they just didn't not file any charges on you. And if they did, in fact, dismiss the charges, you have to see what type of dismissal they entered, because if it was a dismissal dismissed with prejudice versus a dismissed without prejudice, there's a big difference in what really may go on. Because in one, it means they cannot come after him again. They cannot recharge him for that same crime, for that same incident, versus the other. They could dismiss the case, come back, and in turn, dismiss the case, go back, build more evidence, and then come back and recharge him when they feel that they have more evidence to basically possibly get a conviction. So people have to understand. These people keep riding past, but they just make up their mind where they're going. But anyway, so going into Black's Law, what am I in right now? This is Black's Law. This is 6. This is Black's Law 6. It's meant to send away to discharge. And that discharge plays key too, because a lot of people think if you discharge a case or you discharge a debt, you don't understand. A lot of you may not understand the different types of discharge there is, just like the types of dismissals there are. Okay? And just because something is discharged doesn't necessarily mean it's done away with. But that's for a whole nother, or that doesn't necessarily determine that it's completely done away with. So, I'll get into that on another call or something like that. But dismiss, to send away, to discharge, to discontinue, to dispose of, to cause to be removed temporarily or permanently. See, because you can dismiss something temporarily. Something can be dismissed temporarily. Something can be discharged temporarily, or it's many different forms of discharge or uh, dismissal of certain issues and or claims. But again, I'm
Yo, thanks, Princess X.
talk about that because that's really a whole separate topic on me.
Crack lock, yeah, that could work.
But it says to cause to be removed temporarily or permanently, to relieve from duty, to dismiss an action or suit without any.
Sorry, I've been away. I've been in the restroom.
Also discharged.
Just restreaming his shit. That's all.
Or judgment finally disposed of. An action, suit, motion, etc., without trial of an issue involved. Suit may be either voluntary or involuntary because there is a legal term called voluntary dismissal and involuntary dismissal, which, I'm not going to get into all those, but I highly suggest you go look up dismissal and the different forms of dismissal so you are clear as to what options you may have or what defense you may need to get ready for based on what the other parties may come after you attempting to do. And that could also include one trying to dismiss your suit that you may file or your counter suit that you may file.
I'll be back. I'm gonna let that shit play for a minute.
A suit that you filed and you're the one who initiated the suit, whether it be in state court or federal court. You need to understand why your case may have gotten dismissed, or why, if you got a case dismissed against you, you need to understand why did that take place. So, dismissal and order of judgment finally disposed of an action, suit, motion, etc., without trial of an issue involved. Such may either be voluntary or involuntary. And that's according to Federal Rules of Civil Procedure, page 41. A release for this. Oh, no, I didn't like that. Okay, dismissal for non-suit, termination of a case because the plaintiff's failure to prosecute or plaintiff's desire to discontinue. So, termination of a case because plaintiff's failure to prosecute or plaintiff's desire to discontinue. So the plaintiff can desire to discontinue the case, or the plaintiff filed a suit against you but have not followed through with it. It can be dismissed for non-suit. That's what a dismissal for non-suiting. So one can't sue you and just have that case open and just lingering on for a couple years or some dumb stuff. It can't even be linger on for beyond a specific amount of time, depending on if it's civil versus criminal. And one needs to understand that as well, because in a lot of cases you can file a motion to dismiss for non-suit. Meaning the prosecution filed a case against you a year and a half ago, and they keep continuing the case over and over and over again, and they are failing to actually prosecute. It depends on the circumstances in the individual case. Dismissal for cause, you would have to go and see for cause. Now, dismissal without prejudice. These are the key words you need to understand. Dismissal without prejudice. Term meaning dismissed without prejudice to the right of the complainant to sue again on the same cause of action. The effect of the word without prejudice is to prevent the decree of a dismissal from operating as a bar to a subsequent suit. Then you have dismissal with prejudice. Term meaning an adjudication of the merit, a final disposition, barring the right to bring or maintain an action on the same claim or cause. It is res judicata as to every matter litigated. So, if a case is dismissed with prejudice, one can bring the action back up against you. If it's dismissed without prejudice, they can. If it's dismissed with prejudice, one would be barred from bringing the claim back up against you. Because you have dismissed with prejudice, the term meaning an adjudication on the merit, a final disposition, barring the right to bring or maintain an action on the same claim or cause. So if one brings a suit against you for debt, a specific debt, and that case was dismissed with prejudice, they cannot ever come back and file a claim in regards to that specific issue or that specific debt, which basically disposed of. Okay. Then you have the dismissal for want of equity. So you guys have to check out the dismissal. Dismissal for compensation, voluntary dismissal, involuntary dismissal. You know, I'm not going to read them all. But that's coming out of Black's Law 8. Let me go to Black's Law 8. Why I keep calling it 6 to 8. Let me go to Black's Law 8. You know, some of them you got to bounce between the dictionaries because you'll find different things in different ones. And you need to understand all the different breakdowns of these words out there, at least the legal breakdown of it. I'm coming out of Black's Law 8 now. Discuss the termination of an action or claim without further hearing before the trial of an issue involved. And that's federal civil procedures. That's keynote, I guess, 1691 through 1842. Pretrial procedure 501 through 629. And it says dismissal for non-suit, subsection 2-47 and 47-79. You have the dismissal for failure to prosecute, see dismissal for want of prosecution, because the dismissal for want of prosecution will bring you back to a dismissal for non-suit. Dismissal for lack of prosecution, see dismissal for want of prosecution. So even on a dismissal for failure to prosecute, you also have a dismissal for lack of prosecution, because these are going to be some of the key things that you want to know, because you will use them in your memorandum to support whatever type of motion to dismiss that you may put in. Or you may use some of this information to destroy anyone, the opposition motion to dismiss in their memorandum. You'll be able to destroy it because it may not be in line with the rules of the game. Okay, now let me just say it like that. Hopefully that made sense to someone. You have a dismissal for want of equity as a court dismissal of a lawsuit on substantive rather than procedural grounds, because the plaintiff's allegations are found to be untrue or because the plaintiff's pleadings do not state an adequate claim. Now, that's what people need to understand. They may not even be using that terminology, but a lot of your cases may be getting dismissed, like say you sued them or filed suit against them. Some of your cases may be getting dismissed for want of equity. Okay? A lot of you don't even check into the memorandum to support the prosecution's motion to dismiss, and in most instances, most cases, probably they may not have even put in one. Some of them they do. I'm for sure some of them they may not. But again, to go over dismissal for want of equity, dismissal for want of equity is a court dismissal of a lawsuit on substantive rather than procedural grounds, because the plaintiff's allegations are found to be untrue or because the plaintiff's pleadings do not state an adequate claim. So if you are suing them, you that's still choked up. If you are suing them and your case is dismissed, it may have been, if the judge dismisses your case, it may be your case was dismissed for want of prosecution because either your case, how would I say it? Either your case, the allegations that you made in regards to your claim were found to be untrue or what they call unfounded, or you failed to basically put together an adequate case that would make it a claim. You can't file suit and just make presumptions. You have to state a claim. And another thing would be failure to state a claim. They'll dismiss your case for failure to state a claim upon which relief can be granted because you failed to state a claim in which the prosecution can even, or the other parties that even have the opportunity to be able to grant you relief. You can't, like all these billions, people started out suing them for. We all been there, but a lot of us have, a lot of us haven't. So let's think about that. If you, get harmed on the side of the road or something like that, I'm filing $10 billion lawsuit. I got $100 million lien on my UCC and all this and that. Well, just because you got $100 million lien on your property does not mean you go and sue people for $100 billion when they do harm to you. You have to be justified in the amount that you are suing and or requesting for, because a lot of people's cases are dismissed for failure to state a claim upon which relief can be granted based on the fact that there's no way they can be $100 billion. You know what I mean? And we should know that. But that's a whole nother that's a whole nother topic in itself as well. But I just wanted to put that out. So then you have dismissal for warrant of prosecution. You have the dismissal for warrant of equity, what this is went over. Dismissal for warrant of prosecution is, of course, dismissal of a lawsuit because the plaintiff failed to pursue the case diligently towards completion. So if you file a case against them in state court or federal court, and they put it on a docket, and you fail to diligently pursue the case, your case can in fact be dismissed for warrant of prosecution because you failed to basically pursue the case diligently. It's just that simple. And that's in the federal rules of civil procedure, as well as the criminal law and pretrial procedure. You have dismissal with prejudice, because I'm in the 8,060 before. A dismissal that does not bar the plaintiff from refiling the lawsuit within the application, the applicable or applicable, however one pronounce it, limitation period. Meaning if your case, like I said before, your case is dismissed without prejudice, if a case is initiated against you and or criminal charges is initiated against you, and the judge dismisses it, you like your attorney files a motion to dismiss, and the judge in turn issues an order of a dismissal without prejudice. So they dismiss the case against you. They dismiss the prosecution's case against you without prejudice. That means that the case itself at the present time is dismissed. But if the prosecution within the time frame of the statute of limitations in regards to your particular case refiles the case timely, that case can be brought back up against you, and it will not serve as double jeopardy. It will not serve it. There may be a couple circumstances where it may. So, who is Rick Rowe, man? These people are retarded. They don't try to read when you can't read. I just told them, but keep looking at my security camera, you dumb. You are a retarded little guy. Let me get this good. You got blocked. I mean, it's probably puberty came back in as Rick Roll. You guys are funny. Anyway, so a dismissal with prejudice, a dismissal after an adjudication on the merits, barring the plaintiff from prosecuting any later lawsuit on the same claim. If after a dismissal with prejudice, the plaintiff files a latter suit on the same claim, the defendant in the latter suit can assert the defense of res judicata claim preclusion. See, res judicata and the cases in federal civil procedures, and as well as the pretrial procedures, also see dismissal for non-suit. So now, in some instances, basically, because what they break it down, in some instances, the case may be dismissed with prejudice, but then for some reason they're allowed to come back in and refile a case against you, or they do. You need to know that you can basically destroy the case based on the res judicata. Okay? And I highly suggest you guys go check that out. Go look up the definition of these words. But again, a dismissal with prejudice is a dismissal after an adjudication on the merits, barring the plaintiff from prosecuting any latter lawsuit on the same claim. If after a dismissal with prejudice, the plaintiff files a latter suit on the same claim, defendant in the latter suit can assert the defensive res judicata claims include. So basically, you can destroy their attempt to retry you because you got some protections in place with it. But then it goes into dismissal for want of prosecution of a case. Removed from the court's docket because the plaintiff has failed to pursue the case diligently towards completion. Dismissal for want of prosecution under dismissal, number one, and the federal civil procedures as well as pretrial procedures. And also see dismissal for non-suit. So dismissal for want of prosecution, again, is where, the plaintiff, which would have a case against you, failed to pursue or fight, basically failed to pursue the case diligently. That's what it boils down to. Then it goes back in, comes back in with two more definitions of dismissed with prejudice and without prejudice. So dismissed with prejudice, because one's a dismissal without prejudice and dismissal with prejudice. And then you have dismissed without prejudice and dismissed with prejudice. So dismissed with prejudice of a case removed from the court's docket in such a way that the plaintiff may refile the same suit on the same claim. See dismissal without prejudice under dismissal, number one, without prejudice, federal civil procedures and the pretrial procedures and dismissal for non-suit. Because it is dismissed without prejudice, they can refile that case just like they filed it in the beginning. Dismissed with prejudice of a case removed from the court's docket in such a way that the plaintiff is foreclosed from filing a suit again on the same claim or claim. The dismissal with prejudice under dismissal, number one, with prejudice, cases federal civil rules of federal civil procedures and the pretrial procedures, as well as dismissal for non-suit. So, I think these guys should understand what some of you probably already did, but I figured I'd do a little bit of discussing that, and so that people know, because a lot of times the case may be dismissed against you so that they can have more time to gather some evidence. But maybe at the time that they filed the case against you, they can figure out that they got enough evidence to get conviction. So don't really, because the case is dismissed or you believe the case is dismissed against you, sit on your butt like it's over, because it possibly may not be over. You have to be aware as to what type of dismissal it was. Mike is open, see? Star 8, if you want to chime in, if that's shooter of West Oklahoma, you're more than welcome to Star 8. I'll bring you on in so we can hear what's going on about your case, because I believe your case was dismissed, or your daughter's case was dismissed with prejudice versus without prejudice. So people have to understand, because sometimes you think you get a win. I look at it like if it's dismissed, you do get a win, but it may not be the win that you thought you got. And the reason behind me saying that is because it is dismissed without prejudice and can be brought up against you. You only beat the case for the present moment. Until the statute of limitations run out, you're not going to know if you actually in fact beat the case, because they can wait right up to the end of the statute of limitations, but then turn around and recharge you when they have built up some evidence. That's why you see a lot of people arrested for certain things, and then the case is either dismissed or the charges are dismissed. They end up being dismissed with prejudice. Dismissed. Excuse me. They end up being dismissed without prejudice, and then you later see the prosecution coming back and recharge them 2 months down the line, 6 months down the line, 8 months down the line. Well, hell, in some cases, if it was murder, you've seen people get the charges dismissed or the case dismissed, but it was without prejudice. And they came back after him after 10, 15 years because there's no statute of limitations on murder. And that may possibly be happening in some of these fraud cases as well, because there's no statute of limitations on fraud either. So, that's another thing I'll be getting into as well is people understanding the statute of limitations on certain issues because I just about guarantee you that a lot of people are being either prosecuted and or brought in court on some type of civil issue in regards to a case that, the plaintiff may not have found lawfully, being that, the issue at hand, the statute of limitations may have ran out. So that's another thing people need to, look into in regards to their certain issues, because I've seen many people, well, they came after me for a driving case 17 years later and all this mess. Y'all have to understand, that all these different cases have a certain statute of limitations limit on it, meaning that they have to, within a certain amount of time, file charges against you, or they cannot file charges against you. So, but the mic is open, people. You can press *8 if you're there, Oklahoma. You want to go ahead and chime in. I want to hear, eager to hear what's really happening. I don't want to, just from the little bit you said to me, I don't want to tear it up. So, or destroy what actually took place. I'm under the impression that it was a debt case, if I'm not mistaken. Can y'all hear me? Somebody type in the chat, let me know you can hear me. This thing all right? I'm coming through clear. Now down over here, looking at all these, they got a couple people, which I'm gonna mute that. West Oklahoma, you out there? I think there's you go. All right, let me open your mic. West Oklahoma, is that you?
How you doing, too?
I'm all right, and you been missing in action.
Yeah, I actually taken a part-time job. I'm raising the grandchildren, and this particular one day I was at work, and my daughter, I got a call. They always tease me. You're always on the computer. You're always listening to truth. You're always listening. Yeah, you're always into that law, and I specifically told, and I believe it was that daughter. I said, one of these days you're going to be faced with something. You better get into these books. I said, if something ever happens to me, even though I'm the most unlearned person in law, because I like to study medicine. That's what I like to study. And I told them, I said, I'm the most unlearned person, but if anything ever happens to me and you guys need something on law, you have the password to my computer, and you have a wealth of knowledge right there.
Right.
I've listened to you for 2 years. You're one of the first people that I've heard that speak on the law, the issues with the law, and I believe that you come from the private side, and my children, and you do get into the commercial thing as well, and my children, they know you without even knowing you, haven't talked to you. They know about you because I speak about you all the time. I listen to Cheryl. I've listened to Brother Sharif. I've also listened to Brother Don Machiavelli. And I realize that you guys come from all different angles. However, you're the person I listen to the most. And I just here recently learned that you guys have teamed up. Brother Greg Doss, he was on the call as well, with Brother Sharif. And so when she came running up to my job, and I said, "Oh, you're being sued for a medical bill, And as far as we know, she's always had insurance. So at what point in time, if any insurance had been dropped, we didn't know about it. We didn't receive anything in the mail. And I told her, I said, you know what? They've only given you 9 days. They served her 9 days prior to this trial. And it states that the undersigned attorney, and it states her address, and it states that she owed a debt of $981.41. And then it also stated that the attorney was, together with the cost of reasonable attorney fees and interest from the date of judgment. And I told her, you know, I sat her down, I let her listen to some things, particularly on the debt shows that you guys were on. And she didn't, young children, they really don't pay attention. You know, they expect mommy to do everything for her. And I told her, I said, I can't speak for you. You know, you're gonna have to do this yourself. So I basically, with minimal knowledge, she didn't even get a chance to get paperwork in yet. Because when I came home, I'm tired. I'm dealing with the grandchildren. I would get them up in the morning, and then I told her, I said, we'll go do together an entry of affairs. But then I said, hey, wait a minute. I don't know what's the statute of limitation or the time that you have to put this in. So,
Hey, True had some supporters, my nigga. Oh my god. Do y'all not hear this? This bitch is like full blown. Like, yo, we got all True Freeman's information, and if I die, you got the passwords to bro. True Freeman was the go. Like, y'all can't lie. Like, y'all listening right now, True Freeman was the fucking go. Straight up. He fucked that up. Like, he was the fucking go. Y'all not hear? And this bitch is not trolling. This bitch is badass. This bitch said she told her daughters that, yo, I got all the information for True Freeman, and when I die, I got my passwords. Like that shit, some fucking life insurance type shit. Like, yeah, I got 100 bands. You know what I mean? At this place, no. Like, I got a letter. Go find the letter. It tells you where 100 bands is at, and where to dig it up from. Like, what? True Freeman fuck this up? Oh, he's an idiot. I'm sorry, man. This nigga dumb as hell.
So I started doing a little research real quick. I said, well, most states give 20 and 30 days. You've only got 9. But she had an entry of appearance, and she had an answer ready. However, when we called the court, which was yesterday, they could just bring the paperwork in as long as it's sworn in. We had to go downstairs, ran in there, and it was what had happened was I listened to that last show with Brother Sharif when he spoke about being in an accident. And there was a gentleman that called in about a Discover card. And he basically said,
Yeah, I'm back.
what you can do, you can actually call.
Just got my headset on. I'm gonna let Tara talk this crazy shit.
If I could settle the debt with you today, can I settle it with you today? And if they say no, then
Just letting it play. Get my content hours up.
To a collection agency, even though these were attorneys coming after her.
Right.
So we get up in the courtroom and they call her out, the attorney. So of course, me, being the mother chick, I'm gonna jump up right behind her. And so I'm listening to her, and she goes, your oldest dead, and my daughter. The only thing my daughter could say was, I only saw one of the dead. She said, who are you? And she said, well, I'm the attorney for integrity. And at that time, she says, do you have any documentation or anything? Proof that I owe anybody anything. And so she's like, oh, you can go back in the courtroom, we'll get it. So we went back in the courtroom, heard a couple more cases, called her back out. At that particular time, she pulls out her cell phone and she said, do you have an ID? So my daughter said, yeah, I have a state ID. So she pulled the state ID out. And there's my daughter's picture up there, clear as day on her phone. And it was at this time, she said, that's your picture? She said, oh, it looks like me. She said, but this is, I said, oh, that's a different ID, and my daughter turned and she said, well, I did lose my permit, driver's permit. And at that time, she said, is it you? She said, well, look, I can't attest, that's my ID, She said, but it looks like it. She said, well, it's just your signature. Now, at that particular time, you know how difficult it is to see on a cell phone. And she never blew the picture up. And my daughter said,
hold up. So you saying the attorneys for the company had a picture of an old ID, I guess. That they
no,
were
it was the attorney from the debt collection agency.
Yeah, that's what I'm saying. Well,
correct.
Right. The attorney had.
I was listening to this while I was at work. I was cracking up.
Her old ID or driver's license, whatever, on the phone, and showed it her daughter.
Tara going crazy.
Daughter is that her signature. Now, if people go back to that video I did on YouTube, that's been years ago. I want to say almost 3 years ago, maybe. When I was in court, it was right around the time. As a matter of fact, it's the month after my dog case started. So it was somewhere in the beginning of 2012.
Rest in peace, Bruno.
I think that was in February that how I got that disclosed of, it was based on the fact of, not producing a government form of identification. And the fact that they brought up a signature that I couldn't clearly in the court testify was mine because I was under oath. So if I said that was my signature and just so happened not to, I would be perjuring myself. And if I said that was my signature and didn't know for a fact that
Tyra will likely perjure himself. Very likely perjure himself while in court.
Entering in testimony in which I don't know to be true. But go ahead and set it up. Continue.
And so she basically said, well, it's your signature. So my daughter took a good long look. She said, well, it looks like my signature. She's okay. She said, no, I didn't say it was. I said it looks like my signature. And it was at that time I just rolled back. I said, look, basically just because, you have something that appears to be an ID that, that kind of favors her. And even if her name is on it, even if, that looks like her signature, I basically told her, I said, we don't know how you obtain the file. And that's when she said, we didn't buy the debt. We're working for the hospital. I said, oh, really? I said, you work for the hospital. The hospital hired you, huh? She said, yeah. I said, can you produce a check that shows that, well, we get paid only if we win. I said, well, then at least you got to have some kind of contract with the hospital.
Show me the file of done.
Exactly. And I said, do you have a verified sworn affidavit of complaint?
Affy David.
So she said, we got one right here. And my daughter's eyes got real big. And I go, who signed that? I asked her, I said, well, whose signature is that on there? She said, that's the business office. I said, an office signed a document? I said, who signed, what person signed that? She said, the business office. My daughter said, no, that's not what she's asking. She's asking who signed it. She said, some woman. I said, can you get her in here to testify under a sworn affidavit of tenancy of perjury that she can affirm that my daughter was there and she was a witness? She said, oh, well, who are you? Are you her mother? Are you her mother? I said, yeah, well, yes, I am her mother. And she said, well, I can't talk to you. And she can't go up there without, I said, she's going up there. And nothing's going to change. So we went back in the courtroom. The judge called her up. And she said, well, Your Honor, I'm trying to, I brought my tablet in here so that you can see these documents. But she never put the documents on the tablet. And the judge had stated it was hard to see. He said, I can't see and I can't hear. Yes, he was elder. Pardon?
No, you said the judge said what?
He told everyone from the beginning of court that he was hard of seeing and he was hard of hearing. That's how old this guy was. I mean, if somebody would slam the door, just would have blew off of him. But he was a nice judge. I got to give it to him, And she said, well, I brought my tablet in so that I could, blow it up, but she never blew. She said, well, Ms. Price here stated that this is her signature. My daughter said, no, I stated it looks like my signature. At that time, the judge said, and then the judge said, well, is this your signature? She said, it looks like it. I can't say that it is. I don't know. And then he said, well, did you go to Kentucky Hospital? Have you ever been there? And she said, I've been there several times. She said, but I don't know if I've been there on that day in question. She said, what do you mean? She said, well, and she flipped up, and she's only 20 years of age. She said, well, my memory fails me. He said, why? She said, I don't know bad memory. He said, do you understand that if you know something to be true and it is true, and he said, if you don't know that, that's not a good thing. She said, yes, I understand that. But she said, I can't tell you what I did last week. He said, really? He said, do you have a brain injury that took her off? Okay. She said, no, I haven't. She said, I haven't had a brain injury. She said, but to be honest, and she's telling the truth because she told me, she said, I don't remember things up until I was 12 years of age. Anything younger than 12, I don't remember. He said, wow. And so the woman said, well, Your Honor, we have here the date of service. And she mentioned that to my daughter. She said, we have here the date of service. And then my daughter said, she said, can you personally, she said, personally state that you can affirm that I was there on that day? Were you there? And basically the woman said, well, that's when the judge turned and he said, what type of services did she get? Now that's what kind of blew it for her. She said, well, Your Honor, because of the HIPAA law, we couldn't get that from my client. She said, however, listen to this, however, she did receive an albuterol treatment
So how did you get
in the
that?
emergency room. And you know, I'm going, this is one of my brightest children. And at that time, she had phased out, but she should say, objection. If you just stated that your client couldn't violate the HIPAA law, how did you know I had albuterol treatment? And she turns to my daughter and says, do you have asthma? So she actually was privy to some of my daughter's medical information because she, pardon me?
Now go ahead, go ahead.
So I'm saying to myself, if this woman just states that the hospital violated the HIPAA law, I'm sitting up here thinking this because she's stating she knows what type of treatment my daughter had, hollered it out in court, you know, and said that, well, I couldn't get all the records because it would violate the HIPAA law. Well, you've already stated, you know, what she was being treated for.
So you know pretty much they violated the HIPAA law. You know what I mean?
Exactly. And so at that time, she said, well, we're waiting on the witness. So my daughter came back and she sat down, her eyes was big. I said, you all right? I said, look, the worst thing is that we can put a judgment in for the plaintiff. And then, you know, at that particular time, you know, that's when you could start asking for the EIN numbers and stuff like that, you know, because you're doing business, you know. And so she comes back into the courtroom and she said, are you ready to proceed? She said, Your Honor, my witness cannot be here today. She said she suggested you either put in a judgment or dismiss the case. And it was at that particular time the judge said, well, I'm going to dismiss the case.
Hold on, the prosecutor, hold on. The attorney for the hospital, whatever it is, said that, you know, they needed a judgment today. His client said they needed judgment today or dismiss the case.
And I asked my daughter, I said, what was she talking about? She said the witness stated that either the judge puts in the judgment or either dismiss the case today. So I figured it was a bluff. You see what I'm saying? Because she could have easily said, hey, can we get this case postponed until I can subpoena her or she can come in as a witness? And I told her,
the fact of the matter is, I believe they never had the proper documentation to prove their claim, especially when someone challenged them, whether, you know, one screwed up or not. The whole thing of it is we have to get on feet with. My belief is the reason why she brought all the information so-called on the tablet and on phone is because they knew that the information they had, it really was nothing. You know what I mean? They didn't have a case against her, or even if it was her, that they knew they didn't have the proof. And it may have, in fact, exposed some other things that they didn't want to expose. And I think she was trying to call the judge to kind of force him into issuing an order against the alleged defendant, which would have been your daughter, or dismiss the case as if he, you know, wasn't going to take the proper action. You can go ahead and continue with what he ended up asking.
Well, exactly, because I do remember hearing on one of the shows, I believe it was Brother Sharif that said, when you give someone permission to check your credit out, you don't know what's in that background with that credit. I'm pretty sure that there are other people in jobs that she had went and signed in for and who has taken that identification, you see what I'm saying, and made a copy of it. I'm forgetting, they got all of your history, they got to have your pictures in there as well.
Right, because part of their evidence was a copy of an old previous ID that she had, or
that was
which could have
allegedly over a year ago.
Which could have been one of these companies or agents of a company or representatives of a company that you had to forward a copy of the ID may have done something. See, all we need reasonable doubt. And
I basically told my daughter when she came back and sat down, I said, look, worst case scenario, you don't owe the debt unless you owe the debt and you have to prove it. And even with that documentation, who was it signed to? Who did you contract with? That's basically what I was telling my daughter. Even if I said they gotta produce the plaintiff because the plaintiff brings Integrity Baptist Medical Center Incorporated into this courtroom. Basically, she's telling me she could have brought the witness in. I said she didn't even know the name of the woman that was supposedly have sworn to the signed affidavit of complaint. And to be truthful, she had the paper. She never allowed us to see it. And
they probably was forced and or fabricated obligated to leave that because if she had got and a lot of this that thing, I am telling you, not do a video on the in regards to my tax case, because it's back in the appeals court right now. When I do a video to go over the states, but I received this for last Friday, the state's completion of the clerk's records. Now this is the clerk Elizabeth White, whose office has been in Dallas since day one. You know, she's no longer the clerk. She lost the new election. So we have a new clerk now. But everything is falling on the old clerk, right? And completion of her records in regards to my tax case, my property. It's 70 pages long. And it got probably 1,000 properties. It ain't got nothing to do with me. This is my case, though. This is what they do. They don't know what the hell they're doing. You know what I mean? They're doing any and everything because we allowed them to. Let me turn this front porch light on.
Well, at any rate, my daughter turned to me and when he said the case is dismissed with prejudice. And I told her, she said, well,
It's funny how Tyra's talking about medical shit,
they can't
but
come
years
back.
later
I
he
told her,
didn't pay for
they can't come back. I
when
said,
Donna
"You
had her hip
time
replaced,
to
or
prepare
that
a
hip
case
surgery,
to
whatever the hell it was all about.
Right, so
Med One, $6,000. It went to collections. I actually called Med One and told them where to find Donna.
He did say
Off
that
the
he
strength
knew
of
that
D
they can't
Rizzo,
bring it back up.
Finax.
And I'd already informed her that when he said dismissed with prejudice. She said, yes, sir. And then he said, well, okay. He said, just as long as you know they can bring it back up. So I think he was trying to tell the attorney, you don't have all your stuff together. You need to go back and get it together. My problem with the whole situation is her calling, stating that she didn't want to violate, her client didn't want to violate HIPAA law, yet it's still she stood in open court and told what type of treatment my daughter had. Then on top of it, she claimed that she had documentation or sworn affidavit of complaint from someone at Baptist Integrity Medical Center, yet she never put that into evidence to the judge. She never even mentioned it. As far as we know, it could have been a copy of of the court paper that she gave my daughter.
But I think you misreading it because of this dismissal with prejudice that they cannot bring the case back up. They cannot retry that case. They
No,
cannot.
I'm just it was without prejudice.
Oh, it was without prejudice. You were saying if it was with prejudice.
No, I was telling my daughter that it had
Do I have
been
a black
with
pen around here?
prejudice, it came back. I said it was without prejudice.
Oh, okay.
Okay.
Without prejudice, meaning that he basically, depending on the statute of limitations in regards to that issue, they may in turn come back. They may in turn be able to come back and reinitiate the case if, in fact, it was dismissed without prejudice. That's correct.
But the very first thing she told us is that we didn't buy any debt. She said, well, we didn't buy any debt. We worked for the plaintiff. I said, oh, you really? You work for him? You literally work in the hospital. You're up under their policy. This is what you. Oh no, I'm not attorney for him. And that's
Taking in a lot of Tyra today. A lot of Tyra. My God, it's been all day I've been listening to this fucking idiot.
Something that went down, and you come back and regurgitate.
This shit ain't easy.
And if the documentation in regard to the alleged debt, I guarantee you that. Matter of fact, it can be proven because, like, you know, I understand what you said that, like, y'all called them and asked if y'all could settle what they said has already been sent to collections. When it's sent to collections, the debt.
I think I was listening to Tyra from 10 a.m. I ain't stopped since.
Claiming the debt, so even if they work for the hospital is not a real party of interest.
But yet they're coming in the hospital's name.
Well, if the hospital sold the debt, they can't do that. That means the hospital got paid for the debt. Now there's a debt collector that is hired as an attorney, but they're acting as if they are agents of the hospital, which is criminal. That's a fraudulent claim right there. That's filing a false claim to the court of public record.
Well, and not only that,
On the court.
we were told that the debt was $800 something, and it ended up being $981.41. And she stated, "Well, it's $96 for this, and it's $96 for that." But I told her, I said, "But you said that you only get paid that after. So where's the interest and cost and fees coming in? Because I know you're not working for $100 something."
Right, and that's probably it was also probably going to be any judgment was going to be whatever the debt was. If it had been a judgment against you, it would have been whatever the debt allegedly was, 8 something or 9 something, plus whatever court costs, plus whatever alleged attorney's fees that the so-called plaintiff incurred.
But
That's what we can't.
the document states that the defendant owes the plaintiff $981.41. We know for a fact that's not how much she owes.
Right, because her claim is that she don't owe them anything because she don't know about the contract they talk about.
Correct. But yet and still, when she called the hospital for the alleged debt, they said 800 something. Now I do distinctly remember. I think Brother Sharif said it can't be a penny off.
No, it can't be a penny off because that's just like if, and it's common sense. If I buy, just say you owe Sharif $10,000. And Sharif say, "Man, I can't get my money from this sister there. She owe me 10 G. She likes you, man. She really supports you, man. Maybe you can get some of the money back. Man, you want to buy this damn $10,000 debt from me for $1,000, man. And if you can get anything over there, man, you make some." You're like, yeah, I do that. So I go and buy the debt for $1,000. I can't get it from you, and then I'll take you into small claims court and sue you for $10,000. I'm gonna lose my case based on the fact that I know damn well I'm not out of $10,000. The most I can get back is $1,000. Matter of fact, in reality, I can't get back none of it because I didn't contract with you that if I paid your debt off, that you would in turn owe me. But let's just say how they operate. I wouldn't be able to get, even if they gave me a judgment, knowing that I really could get a judgment, the most that I could even request is $1,000 that I'm
I've had a long day with this dude, Tyra.
And,
Long day.
Late fee.
Damn.
The scam went on. That's what they do.
Well, I'm assuming this is a scam then, because it even after it said the defendant owes the plaintiff the $981.41 for the amount due on the account.
And who is the listed plaintiff on the claim, though?
Integral Baptist Medical Center.
Oh,
Do my grocery list, checking my laundry. I'll be back in a minute.
I, the undersigned attorney for the plaintiff, but it says together with the court costs, a reasonable attorney's fee and interest. So basically, that's separate from what they say she owes them, and she allegedly.
That's on any suit, though. Anytime you sue someone or someone sues you, if you lose, you are liable for whatever court costs they incurred, whatever penalties and late fees, as well as attorney's fees in regard to the case. That ends up being on top of the debt, the alleged debt itself. So if it was $900 and the attorney's fees were $1,500 and the court costs and fees ended up being another $500. You know what I mean? Then you do the math. That debt
Okay.
is almost $3,000.
Checking my laundry.
Yet the alleged debt is higher than what the hospital reports that she owes them. So we got a conflict right there.
Because the hospital is claiming 8 something, but the claim is claiming 9 something on top of the other 15 outside of the 9 something. They're claiming that the 9 something is the original debt. That's what you're saying when in fact the hospital is claiming it to be 8. Yeah, so that's even within itself and what Brother Sharif is pretty much referring to is in regards to it's not just in regards to debt collectors because, people have to understand anybody coming after you to collect your debt as a debt collector can be construed to be a debt collector. You see what I'm saying? If you are attempting to collect a debt, I mean by definition and by default you would be a debt collector. Now some people may fall up under the label of being the original lender, but even the original lender is attempting to collect his debt. So still, you know, the you know, be considered a debt collector. You know, it's an order. But
He's not a real party in interest.
who is
But the attorney.
Oh no, the attorney is definitely not. But I was thinking that maybe they sold off the debt because you did say that it went to collection.
That's what the
But
hospital
it don't.
said.
Well, if it went to collections, then the debt has been sold. See, they're hiding something. So then you definitely, without a doubt, will be dealing with a debt collector, and the attorneys for the debt collector is basically committing fraud on the court by claiming that they are representing the alleged
Excuse me.
original creditor, when in fact they are probably representing the company or corporation that the debt was sold to. Because again, when you come, and I know this to be true because when you that's just like 1 year, you know, this is even before I got into this information. I had a couple things on my credit. I want to attempt to clean
Yeah,
up
Tyra's
my
credit is
Okay, let me
fucked.
start calling.
Hang on, let me pause. Let me pause. PAWS, pause. Tyra's credit is fucked up. D-Rizzo gave me some very good leads, or more so information, the other night. He owes $13,000 in court fees, $25,000 in child support, and he's probably got some other shit. Tyra's total debt is probably, you take the 25, you take the 13. He's the better part of 40,000 plus in debt. That's the reason why Tyra will not get an actual job, because as soon as he gets a job, and I'm citing victim own when I say this, Tyra knows he's going to get garnished. He'll be working for free. Hence why everything Tyra does for income, it's got to be Cash App, Cash, or Squarespace. Tyra is a tax cheat. Tyra is earning an income and cheating the state of Indiana, why can I talk? And screwing the state of Indiana out of tax revenue. Tyra is a tax cheat, no different than his boy and idol, Donald Trump. Two of them are one and the goddamn same. Let's continue.
This is before I know anything about this. This is beyond 10 years ago. And I was, you know, calling and they'd be like, well, you can't pay it because, you know, we pretty much don't own it. The debt is not with us anymore. It's with the credit. It's with your credit agency. It's with it's with someone else. You can't. There's nothing we can do. Now, if you basically hire someone to come after me and get the debt, you can't tell me if I come to you before they come to me and offer to settle the debt. You can't tell me that you can't settle the debt, with the exception of if you sold the debt and I can't pay you because you already got paid for it with whatever agreement you had with them. So you gonna refer me to them to pay the debt so they get their money back in which they gave you. They don't want to admit that they sold the debt. But if it goes to the credit collections agency, they didn't sold the debt to the credit collections agency. That's why they spend so much time trying to get the money. You know, we got 10,000 contracts, or
Excuse me.
you know, we got 10,000 debts we got here at Indianapolis Hospital. You know, Eskenazi. And, you know, they haven't paid. We want to, you know, they totaling $487,000. We willing to sell it to y'all for, you know, $10,000. If y'all can get from all these different people, y'all get it. But I'm sure y'all get more than, you know, the $10,000 that you put in. They buy the debt, and they start hounding you, and they act like they're operating on behalf of the alleged individual and or company that you so-called had some type of contract and or interaction with, which in fact, they're pretty much a debt collector because they bought the debt, and in fact, they're trying to, again, you know, con the court by claiming they represent the original so-called lender. I got a hand up, or creditor. I got a hand up real quick because this brother from North Kentucky, I believe. Let me go ahead and open the mic because it may be something to add to what you're talking about. No, you're not finished. You're still open. Let me open up because, you know, you've been waiting for quite some time.
What's up, too, man? What's up, too?
Yeah. Not much. You on the plantation, ain't you?
Yes, I am. I know you can hear the noise, but I just got something to ask. Like, check this out.
Go ahead.
When you go into the hospital and you sign the paperwork to go in and get the treatments and all that stuff, you waive your rights to HIPAA. That's why that lady had the information on it. Now, what I would do,
Whoa, say it again, because I didn't know this. I don't go to the hospital.
Yeah, I didn't know you waived the right.
I didn't know that.
HIPAA law.
yes, you waive your rights to HIPAA when you sign those papers. That's why that lady had
Donna Hippo, what's the difference?
So, this is what I would
Oversized bitch.
being that that lady had the information and your stuff was dismissed with prejudice, I would immediately sue the debt collector off top. In small claims court, I'll get that $1,000 or $1,500, whatever they're gonna give you in small claims court. Then I would turn around and sue them for pain and suffering. Or what kind of pain and suffering did you? I was stressed out. I got to take medication because of I was stressed out over this deal, and I don't even know anything about this deal. So that's what I would do with the situation. Remember I told you we was in Louisville through and we was working on some shit. Well, that HIPAA law is some of the shit that we was working on. I found out I got a medical bill from Baptist Peace, and it said that I owe like $1,400. And I'm like, what the fuck is this shit? But it was a lawyer who was coming through. It's called GLA Services. They was trying to collect the debt. So what I did was they took me to court to try to get this money. And when they took me to court, I disputed everything. And when I got to disputing everything, I won that little thing with prejudice. So then I took them to court in small claims court. Well, you know, when you go to small claims court, there's no attorneys that can be involved. It's you.
Well, it kind of was not actually in everything. But here in Indiana, it's 1,000. So they did.
I'm fading out. You're fading out.
I'm saying now.
Yes.
Yeah,
Oh, you gotta hear me now.
I can hear you.
Okay, yeah, because I said here in Indiana, it's like one in civil court judge, if they can actually, in fact, hire an attorney to handle the case themselves. Well, they give that option, but in most cases, the reason why you won't see attorneys pretty much in small claims court is because the attorney fees outweigh the amount they wanted to pay. But in some states, although they should not be able to do this in Indiana statutes of small claims, so they allow people to want to force behind attorney. That's
But what I did is I took them to small claims court, and what ended up happening was no one showed up, so I got a declaratory judgment.
Whoa.
Once I got the declaratory judgment against them, I sent them a letter of verification showing that, stating that I need them to show everything that they have on me, and because they put all this shit on my credit report, and when they took all the papers of what I owed from this Baptist East and all the stuff that they did, well, they violated HIPAA rights, and so I sued them, and I actually took them to court, and right now we just trying to. I won the case. We trying to settle to see how much money that I'm going to get because I told them that I lost my chances of getting a house because which is $188,000, and I'm suing them for triple the damn thing of losing that house. And so, so because I used to show I got paperwork showing I wasn't able to get the house, but I didn't get the house because of the bid when I placed my bid on the house. But anyway, so. We actually going back to court for that, and we went back to court for that, and they trying to figure out what they can settle for because I'm actually if I sue them for triple the damage, the company's gonna be shut down.
Right.
And that company got a reputation in suing people and giving it debt collection for a while. And if they sue and I take the company, it's curtains to them. They can't. I'm automatically taking their bond to do business. So that's where I'm at. Remember, I told you a while back that I was dealing with some shit at my job. I mean, dealing with some shit that I've been working on. That's why I didn't call. And that's what I was working on right there. That HIPAA law is something else that everybody needs to look into when you go into the hospital. All the papers that they say, oh, this is this, and this is this. You sign away your HIPAA rights.
Yeah, but they don't even give you full disclosure. They sign away a right that a lawyer, the attorney stood in open court and said she couldn't violate.
But that's called stagger. But see, here's the deal. You don't know that they signed away your HIPAA rights because you thinking that whatever they say, oh, this means this. This is just saying that you give us permission to do this. This is just saying you give us permission to do that. This, you know, and
But a lot of times them contracts do in there say if you agree to this, that, or else, you wait to agree to this, somebody or else. Just like people don't understand, like for they were filling out those waiver of attorney forms, and I told people like, yeah, judge, let me represent myself. I had to, I went on and filled out the waiver of attorney form, so I'm going in. I said, do you know what you just did? He like, no, man, ain't that good? I'm like, hold up, you signed the waiver of attorney form? They like, yeah. I said, did you read the waiver of attorney form? They say, not, well, I did, but what you talking about? I'm like, look, man, do you understand that one of those paragraphs in you waiving your right to an attorney, that you are also, in fact, giving the judge the ability to possibly be able to rule that you ain't competent to represent yourself? That's one of these agreements that you agreed to while signing that waiver of attorney. Because by you waiving your attorney, you're leaving the discretion on the judge as to if
Tyler's lost for words. He's lost for words.
In fact, represent yourself. I want to represent myself, but using the terms that they use, basically, I say defending yourself. What you're doing is basically you setting yourself up, because if at any point in time after you sign that waiver of attorney form, if you go in and you are giving him the business, the judge can pull a fast one on you and basically order you to have a mental evaluation and then turn around and rule that you are incompetent to represent yourself, therefore appointing you a public defender, and it shuts you down in whatever defense that you had that possibly may have been winning, but people don't understand why. If you sign a power of attorney form, if you ever ask and you have it, and you just mentioned something that made me bring that up. If you ever have, pull it out and look at it and actually read it and see that you just give the judge, you just find giving the judge the power to rule that you incompetent to represent yourself. Therefore, they're going to appoint you counsel. And a lot of you jump off a bridge and cry about it and wonder, well, I'm able to represent not when you contract at any point in time, the judge can rule that you incompetent to represent yourself and appoint you counsel. So even with these contracts we signed with the hospital, like last time I was in the hospital, actually was in regard to that case that I didn't have insurance, so they ended up suing me, although it was their fault. And that was that one case I put on YouTube. The audio ain't that good. It was only me and my buddy in the court because they cleared the courtroom, and he was sitting way back, basically because of the courtroom we was in. It was only 3 long rows across, but they had the audience way back. Actual,
feel me?
The bench.
Wait.
So, I guess it didn't pick it up too good. But it's good enough to hear. You know what I mean? People just don't, pay attention. Put some speakers up or something and turn it up. You'll be able to hear it. And it boils down to me not agreeing that was a signature on that alleged bump, and me not producing a government form of identification to identify myself as the all-cap name, and that's how the case ended up getting dissolved. Okay? And our problem is even in these like in these medical cases and things like that, is we don't read the contract. You know, so not all the time can we sit up here and claim we weren't given full disclosure. If in fact we read the contract at a later date and find out that it did state that in the contract, you just didn't know because the contract was 5,484 pages long. So some responsibility lies upon us in reading the actual contract before we sign it, although we did not know. Also, in most contracts that people have signed, the full disclosure clearly was not given within the contract, i.e., it's out of life contract. All that garbage that they do is not in the original application for a driver's license or a state ID and all that other mess. But again, they hit us up every time with the law and excuse. So that's what we have to come together and educate ourselves so we are prepared for the waters that are here. And a dismissal with prejudice versus a dismissal without prejudice is key because we need to start going after
Probably get a shower now too.
cases dismissed without prejudice. With prejudice, so we don't have to worry about coming back after us and recharge. You go ahead, brother, or sister, who's ever there.
You talked them off the line, Tyra.
Well, what hospitals are doing is they make you sign an electronic signature.
Exactly.
So you don't get the full disclosures of everything that you're signing for. And even if you do sign something to see medical treatment in that hospital, what happens is you don't get the papers on that, so full disclosures are not gonna come out.
Right. Yeah, and a lot of and in some instances it don't, but in some instances they do. Just like pretty much. Well, it depends on what you discover because even with the mortgages, they give you a stack of documents that's 10 pounds. That weighs 10 pounds. And we just sign. Don't read. Although even a lot of the things that they are doing or that is involved in the contract, they in fact. It may not be told to us in the contract, but one has to be privy to that information in order to know if it was disclosed or if it wasn't disclosed. Because, like for instance, like the mortgages and things like that, when one signs these contracts.
Yep, Tyra talking about
if
mortgages.
Look at the contract. If you notice, a lot of people's mortgages, when they originally sign a mortgage, they mortgage is sold within the first 30 to 90 days.
The irony.
They mortgage is sold to someone else automatically. So if you
Tyra talking about
mortgages,
mortgages.
that company hasn't already got paid for your signature. Why would they already be selling it if you only 2-3 months into the contract? Why would they sell it? Because they didn't already got paid. They got 2-3 payments from you. They're gonna go ahead and sell it off before you choose not to pay. Because they've already got the credit, and this is even with the hospital bills and things like that. This is why they need that social security number, because that social security number gives them access to the trust to be able to get digital credit, and then in turn be able to, if they can convince you that they lent you something, they can make a profit by making you make back payments for something that they claim they loaned you, and in fact they haven't loaned you anything. They just use your identification to access an account that you don't know exists or that you don't know how to use.
And then I also have something to add to that. You also have to look at the settings by which you're signing the contract. If something happens to me, and you see what I'm saying, and someone brings my will to court, somebody could argue I wasn't in my right frame of mind, my mental competency. So if I'm sick and I go into a hospital, am I really in my right frame of mind if I'm ill?
Great point. Good point. I knew that's where you were going. Good point, because a lot of these contracts could be voided based on that within itself. Why? If I go to the hospital and I done just got shot 5 times, but I'm still alive and talking, and before y'all do any work on me, y'all got me signing paperwork, I'm not reading anything, I'm distraught, I'm not in my right mind because I think I'm gonna die. That contract pretty much is void within itself. It's like you can't, and then not only that. Let me say it like this: you have a lot of people that they enter into these contracts while under the influence of some type of drug. How can one be in a right state of mind signing a contract when they own Ritalin, Vicodin, whatever it may be? You know what I mean? But they can send you out because they want your signature. They want their signature. They want their social security number. They want your agreement because that, for one, gives them access to get the digital credit, and for two, that allows the company the ability to be able to possibly make profit if you feel that you will own something and you're supposed to be paying something back. That's why it's selling off so quick. Go ahead, brother.
Now that was me. That was basically null and void virtually every contract out here, because if they have us as a ward of the state and that we're so ignorant or we're mentally incompetent to understand what it is, in law we have to be judged by what we know, not what we don't know. Even though they say ignorance of the law is no excuse. Well, then I would like for you to tell a Mongolian idiot or someone who commits a crime and doesn't know the difference between wrong and right. We will never talk that difference because we're incapacitated mentally because we have not been taught that.
Mm-hmm. Now and then another thing, you just made me think of something else. Just like when people are signing these contracts, of course I don't know that there's that type of defense may work, but it may. But it's just something to think about. It's like if one is even agreeing that they are a legal fiction, which a legal fiction does not really exist in reality. It only exists on a piece of paper. Even if that legal fiction signed that contract, wouldn't that contract be void because the entity in fact does not exist in law where it would be able to sign for itself? So if the debt is against the all cap entity, the all cap entity or the all cap name or a legal person, legal fiction, fictitious entity is in fact a piece of paper, how could they contract to something? And see, what people don't understand is what they're doing. Well, a lot of people do understand, but it's like what they're doing is that they are involved in a major fraud operation. Because it's like you're taking an all cap, now you're taking a corporation and a private individual, actual living man or woman, and you are actually basically combining the two, and you are charging one individual for another individual's debt. And I say that for a reason because there's multiple different definitions of an individual. An individual does describe an actual flesh and blood individual. It does also describe a corporation, depending on which definition you're going to use. But with that said, they're blending the two. And on top of that, you're sitting up here. That's just like someone coming after you for a debt that I owe. And we don't know each other. Or even if we did know each other, we are two separate individuals. We are two separate people. You see what I mean? But they feel because our names are similar that they are going to go after everyone that name appears to be in that same, somewhat that same format. And then my wife, because of her name, it's like coming after her for somebody's singular. Well, they were doing this like a year or so ago, about, well, maybe a couple of years ago, about a singular one cell phone that she's never had a phone with singular one. We ain't never been with singular one, never. And they could try to get one to give up the social security number to see if it matched. Oh, because if you got the social security number, you can read me out the last four to let me know, so I would know if you actually in fact got the right individual with that name. You see what I'm saying? They just go after anybody. You know what I mean? But with the use of the all cap name, which is what they are using, it's our duty and responsibility to separate ourselves from that so we can control it. And if that individual owes a debt, then that individual is liable. It's just, it's not my fault. That individual only exists on the piece of paper and cannot ever pay that debt anyway. So I mean, it depends on how they want to play. And that's what I did in that one case against me. It was a civil death. They got shut down. Got shut down. There was no judgment there. The judge continued the case indefinitely. The attorneys for the other party was they were trying to get the judge to dismiss the case. She refused to dismiss the case, and I guess she was just mad. I'm not letting him be mean. Well, I'm not going to do that. I'm just going to dismiss. I'm going to continue this case indefinitely, and Mr. Barr will contact you whenever we feel like setting the date. I'm like, are you serious? And I'm like, that is just ridiculous. They did not want to, and they knew my buddy was recording, because if you look at the camera, they had the clerk come back there, walk all the way up on the camera, and tell him to turn it off. He act like he did, but he didn't, and they know he did, and they came back again, and you could see that video. I mean, they knew what was going on. That's why they had me in the private. They took me in a little closet courtroom that time, and it was like that was only my second time in court at that point. You know, so
I have a question.
I mean, okay, go ahead. And anybody else got something to say? Y'all can raise your hand. Sorry, go ahead.
When they ask for a specific amount of dollars, I overheard a gentleman by the name, I think it's his name, Tim or some sort of Turner. He mentioned the case that a dollar is a unit of measurement, because the dollars were measured in ounces of gold and silver. So to say somebody owes you $941, dollars of what? If a dollar is a unit of measurement. Now, there is a case floating around out here. I don't have the name of that case. I have it written down in the house here somewhere. But it states that one guy had received a judgment since he kept hollering to the judge, $4,000-something of what? Dollars a unit of measurement. So finally the judge slammed the mallet and said, pay him in coffee beans.
I never found that case of Tim Turner supposed to be got indicted and all that old mess, but he put out some, he was a 75-25. He put out 75% of some good information, but the 25 destroyed the rest of those who couldn't comprehend. He supposed to be indicted. Go ahead.
The question is that a fact?
Is that a fact in regards to
a dollar being a unit of measurement?
Oh, your dollar is a unit of measurement. Here's the thing, if you challenge them, okay, I have no problem paying the lead debt of $1,585. But before I can pay that, I need one to define what is a dollar. In fact, what type of dollar are you referring to? If you can define an actual dollar, I'll pay you in dollars.
Because that's just asking for 1,500 inches of what? Wood, steel, metal? I mean, what do you want?
What it boils down to is basically what everyone really pretty much accepts, not necessarily with the dollar, but it goes to the wealth. Because see, people may say they're wealthy because they got a lot of Federal Reserve money. But people may have a lot of knowledge, and you're wealthy too. Some may have a lot of assets, say land. You're wealthy with land. So it does not necessarily describe money when one is considered to have wealth. You know, wealth is wealth is pretty much anything that is exchangeable, that you can use, you know. So being that people are ignorant to the fact of what Federal Reserve notes actually are, you know, it can be construed, shall I say, to be a form of wealth. But at the same time, you will not be able to get them to define what a dollar bill is. Because they definitely can't tell you got to pay 100, like say the debt is for 10,000 so-called dollars. They're not going to define a dollar to be a Federal Reserve note. They cannot demand you to pay in a certain form of currency as well. So they can't define it as $10,000 is 10,000 Federal Reserve note because you can pay by what they call cash, check, money order. Uh, uh, there's different forms of payment, electronic funds transfer. Different forms of payment, and like what they came.
God damn this dude, man.
I didn't never come across the case, but because I was, been in the damn terms.
Hour and 10 minutes left.
About 5-6 years ago, and started seeing a lot of bull crap as well. But there was some good information out there. There was something else I was getting ready to say about that. It kind of flew from my mind. Yeah, I can't even know what else I was getting. It was something else I was thinking about, but I kind of got off track in regards to the situation. But the thing of it is, a lot of people don't understand what type of dollars are already talking about as well. Because if you want me to pay in a certain form of currency, that's going to violate quite a few things. You see what I mean? Because you can't demand a specific form of currency. You can't say that if I allegedly owe you $1,000, you can't say specifically I have to give you 1,000 Federal Reserve notes unless we have a contract that specifically calls for me to pay you back in a specific form. And again, you're not paying anyway because the Federal Reserve note is not paying a debt. It's a promise to pay. So the fact of the matter is, people believe that they are getting paid when they're not, and it's only because people didn't give them. They basically can be used because people give them value. Is what I'm trying to say. So Federal Reserve notes only have value because people believe they have value. If you had a brand new 745 or 750 BMW and you wanted, and I convinced you to trade me for 500 rocks that I said had some magical power, then I'm wealthy. If you take that and we exchange, you exchange the BMW for my 500 rocks, I paid for the vehicle. It's part of the contract. You agreed to take the 500 rocks for the vehicle. You thought they had some type of mysterious power that you were looking for. And it works the same way with Federal Reserve notes. If you can convince someone that something is worth something, then it has some type of power. But Federal Reserve notes don't have the specific value in which they claim.
I have one other question before I yield the floor. On this document, it states a lien was claimed.
On the debt, on the hospital document.
On the affidavit. On the affidavit.
Affidavit.
Okay, what affidavit?
The affidavit that the attorney put into the court.
It's claiming a lien on what?
It says it just says lien claim.
That's too vague to.
That's on the body of the person that they claim, like if they found two gets the daughter, and they found a lien, they put a lien in the daughter. Say that's the lien for.
Right, but it's vague. They can't put a lien. They can't literally put a lien on something without a court judgment. It's a corporation. You have to get a court judgment. You can't just up and just put a lien on somebody's shit.
Well, it says lien claim.
Well, they can. It's just like they. It's just like
no, I ain't saying they won't. I'm just saying what they my law. Well, they have done that before they dare can claim. Before they dare can put a lien on the alleged individual or any of their property and or assets. And let me ask you a question. If they say that's just what it says, has this case been litigated in court before where they received the judgment?
No.
It's never been before.
No, it hasn't. As a matter of fact, on this affidavit, I could see where there was a date of November, something on there, but they whited it out and put December 1st.
Okay, now for sure. Is there any possibility that they may have had a hearing in regard to this case before this last filing or whatever, or this filing?
If there was a case, we had no knowledge of it.
Because that could in fact be the case in which they pulled that little strings, which they didn't do. And that's what they did on the case that I ended up getting basically wiped out, was that they claimed that, the original court got a judgment, and then, it basically was almost at the 7 years at that time they brought me back in. It was at 7 years from when they claimed, it was almost at the 7-year statute of limitations, which they wouldn't even be able to flex for. You see what I mean? So what they was doing was bringing me back in, but there's a lot of traffic, man. What's going on? Y'all got to feel the standing tip of quite a few things right now. But what they had did was they had some type of hearing before and claimed I failed to appear. So then when they went in, they claimed, because they had actually, in fact, ended up putting it on my credit report. Now, it was on my credit report before I even ended up going into that hearing that's on YouTube. So that's why I asked you, was there a possibility that there was a hearing on this before in which they could have received the judgment, and if they received the judgment, then they was within, even if the judgment is illegal, if they have a judgment and it's not being challenged, then they will be within their right attaching a lien to the alleged individual and or any collateral that's in the name of the individual that owes the debt.
Well, number one, they never went. We checked her credit report. Now, I have to check the other two report agencies, but that debt is not up on the credit report.
It may not be. It may not be. They may not have filed with the credit reporting agency, and it may be that you need to check the public records to see if you can check the public records in regards to her name. And
go on the Secretary of State.
No, you're gonna have to go into the public records. Y'all got a site down there. There's a state site that the public records, court records, civil and criminal cases. You should be able to have to pay a few dollars a page or something like that to pull it offline or something. But you're gonna have to do a public record search in regards to court cases. That's what you're gonna have to do. Like here in Indiana, it's Odyssey, it's Odyssey Records, it's what's the other one? It's like three different ones that they use down here. It's Odyssey, there's something else on the IndyGov site, and it's the one Carol had exposed DocSpot. DocSpot here, DocSpot here, Odyssey Records here, and I can't think of the other one. It's at least three of them here, and you can check and do a public record search, and if whether the case was dismissed or it's still open, it still should be in the public record. And if anything pops up that has to do with that specific hospital bill, you will need to pull those records to see if they did something. They claim they properly served her and got a judgment for one failure to appear.
So why would she be drugged into court this time if they already got a judgment on it?
Because they're trying to collect the debt. So they will bring you back in years down the line and bring you in. But did they bring her back in for to basically pretty much liquidate her assets?
No, this is just to be heard on this case from what I'm understanding.
So I can't see anything that would justify them actually, in fact, having a lien. Maybe they were just claiming to what they were claiming in regards to the judgment at that time. Maybe that's what it was. Because they can't put a lien on anything unless it was in the original contract, and we're dealing with a hospital bill. So me not reading the actual hospital bill, I can't confirm whether it says it or not. So I'm not going to say that. I don't know what the hospital contract, the contract they signed at the hospital in fact says. But if they didn't have any prior judgment, a prior judgment in the court, and this was the first court hearing, I can't see anything that would lawfully that they would have that would justify them already having a lien. So I'm just going to reach out there and assume that they were claiming a lien in regards to whatever judgment was in that case that was going on at that time. Maybe I'm wrong. I'm not for sure. I would have to, know. Go ahead, brother. Go ahead.
Well, I know this is both in Kentucky. They had all the information. So the only way you're gonna get the information on whether or not they took out a lien on the estate is that you got to do a UCC 11 and make sure that your title comes back clean, because a lot of times they take the liens out on people and people don't know that they have liens out on them. So that's one way you can check it.
Okay.
Only way, because that lien has to be recorded in the county recorders in their county. It has to. Any lien has to be recorded in the register of deeds. It should be in the register of deeds or the deed registry in that county, because it has something to do with property, whether it be your home, your automobile, whatever it may be, is going to be in the deed registry, and that lien should be there. That way, that if anyone searches, does a title search in regards to the name, which is property, or any other form of property, that anyone that has previously claimed some type of lien in regards to that property will come up. So even if you do a UCC 11, and you find a lien on your property that is not recorded in the county recorder, then there's a problem, because the state law requires them to record, first of all, give notice and then record their deed in the public record. You see what I'm saying? Which would be into the registry, the register of deeds in the county.
See, another funny thing they're doing, they put the information in the newspaper, and people are not seeing the information in the newspaper, or they put it online to where you can't see the information in place online. It's still in public access, but you don't see it. So that gives them the right to pay them on it too.
But they can't record it. They can't record it in the paper, or they can't record it online like that. They have to record it in the report. Usually off. But for us to notice, they're doing it online and they're doing it in the newspaper. And they know everybody don't read the damn newspaper. A lot of people go online, and a lot of people don't even go online and read the newspaper online. You know what I mean? So they know you're not looking. They expect you to pick up a newspaper every day and check the public notice section. So
Okay.
This is another way that they are getting over and getting quiet titles and all this other mess and getting liens.
I wonder what happened to send him over the edge. Man, Tyra's been fucked up.
But they still have to go into a court and get a judgment.
Tommy and the trolls and the alcohol, that's what sent him over the edge, Mr. Golden.
Their lane, right? And then they have to record that lane into the record in the county. So you will find out a lot of them will not. You know, a lot
You
of
did
them
damage
not.
to him.
You know, they claim in lanes when in fact there is no lane.
Oh, we went tire intensive and messed him up.
Putting in valid lanes on people's properties and access. So I mean, every case is different. You know what I mean? You just have to look into your case itself and see what actually in fact took place. You know, because every case is not going to be exactly the same. You know, and who goes and checks the newspaper every day?
Some people do,
who goes
Tyra.
and buys the newspaper and checks the public, what is it called? I just public notice section of the newspaper. Who goes online on a daily basis to check the public notice section to see every day if somebody happens to be filing a claim against you? And this is how they getting away with pretty much murder, because they know people don't look. So what they do to get notice, they put it in the very place that they know we don't look. The newspaper, on the public notice board in the courthouse in the county. A lot of people don't even know about that. They're talking about that for years. So I couldn't get my document filed in the county. I was trying to get public notice, put it in the newspaper. Well, I can't put the whole document in the newspaper. So we had notice to the document in the newspaper and posted on the public notice board in the courthouse, which the rules in the statutes and codes of the state clearly acknowledge is a form of public notice. And hey, if they want to block you from that, you just figure out the other ways around. Because that's what they're doing. They're finding out where you don't look, and that's where they give the public notice. They know we don't go down to the county and check the public records. They know we don't get on the line online on a regular basis and check the public records. So they file things in the newspaper. They file it online in the public notice section. They put it on the bulletin board in the courthouse. Just like when they foreclosing on property. You go down to any courthouse in any county, you look on that board. Every time around tax sale, that board is full of properties that's up for the tax sale. That's a form of public notice. But what does that say? That say that they are expecting you to go to the courthouse and look at that board. They expecting you to buy a newspaper every day and read the public notice section, which they know we don't do. So they're able to pull over a lot of things based on the fact that we don't look at some of the things we need to look at, so we will be aware if the claim is being made again, which is something we need to do. You know, not that we can do it every day because it's bull crap.
Hey, true.
Go ahead.
I jumped a car back a while ago because the thing when it started, I didn't want to put any more money in it, so I went and got me another car. I jumped it. So the junkyard came here and they gave me a little check for the car. They left with the car. But I took the title up to a bank. I got it notarized and everything for him. And he went off. I got some notices in the mail with 2 power of attorney forms. Something about disposal of the vehicle.
Okay.
The title change, the disposal of the vehicle. And I'm like, I thought they were supposed to do that when I signed that title over to them.
And they took you 2 power of attorneys for what?
That's what I was like, what is this about? Well, don't you have a claim in? I said, who are you? They say an insurance company. I say, an insurance company? I said, ma'am, I jumped the car. And they called me again today.
Okay, just what you said thus far.
Okay.
Somebody got a claim in with your insurance company in regards to that car.
No, I let the insurance go on because I
fucking freezing this room.
I'm gonna get rid of it. Why pay insurance on a car you're not gonna have?
Right. So what I'm saying is, who called you and said that you got a claim? Don't you got a claim on that car?
On the, something they wrote something along the lines about I need to sign a power of attorney form.
No, I'm asking you who was that?
It's an insurance company.
But it wasn't your insurance company.
No, it wasn't. And when I looked at
I'm gonna tell you right out. I'm hearing what I'm hearing. Somebody's using your identity.
Yeah, that's
somebody
what
that
I
got
thought.
to do with that car you sold. Somebody's attempting to use your identity and have the car in your name to get a claim made out. Now I don't know why they contacted you. Maybe they didn't think that they shouldn't have given your phone number, but they should have given their phone number so that they can continue to act like you and scam him and get the check to be able to cash. That's what I see, because if you sold that car to a scrapyard, how can someone file a claim with an insurance company on that vehicle except the scrapyard or somebody working in the scrapyard? Or somebody that the scrapyard may have sold the vehicle to without transferring the vehicle out of your name into the scrapyard's name before we sell it. I don't know. Those are some things that just pop up right off the top of my head. Because I've dealt with a lot of different situations like that, but without actually knowing with the insurance company contacting you, you're not knowing the insurance company, and they're thinking that you have made a claim with the insurance company in regards to a vehicle you already sold and you didn't. Someone's acting like you. They're you.
Oh, okay.
And someone's using that vehicle to do it.
All right. Because they keep
That's what I.
they keep mentioning this. I've gotten 3 letters from these people and 2 phone calls, and it was a
Okay,
claims
well,
department.
Okay, well, you need to find out because if it's involving you and somebody's trying to commit some fraud, you need to get with that insurance company and put a halt to that.
Well,
First
they
of
keep
all,
trying to
you
get me.
need to let.
They keep
You don't give
trying
them
to
any
get me to
personal
give the,
information.
they keep trying to get me to contract with them. They said I need the claim number. I said, ma'am, I haven't claimed anything.
Well, that's not necessarily meaning they're trying to get you to contract with them. If someone has submitted a claim with them and claiming to be you, pretty much they can't talk to you unless they have the claim number. If
Yeah,
the
but if I
claim
give them
has
the
already,
claim number, I explained to them I jumped the car. They said, well, maybe we have the wrong, because I thought maybe they thought, oh, we goofed up. They said, well, maybe we're supposed to be contacting the scrapyard. But I got 2 more calls since then and 2 more letters since then with the power of attorney.
yeah, you definitely don't want to sign that. Like I said, especially if you haven't filed a claim. If you haven't filed a claim, somebody's trying to file a claim in regards to their vehicle. Somebody's trying to commit some fraud. My thing is you need to figure out what's going on.
Why is Tyra
Make sure
worried
your
about
damn
fraud?
name
You
is
do
clear.
fraud all the time.
Right.
You
Because
do with Donna's fucking SSI check and the mother's SSI
to
check.
attempt to file a claim with an insurance agency, and which would be fraudulent. And believe me, if your name is being used, you're going to be the one they come after when they figure it out. So you need to, if it's an insurance company, you need, I can't give you a claim number in which there's no claim that should exist with my name on it. So if someone is using that vehicle in my name to submit an insurance claim with you, I suggest you do an investigation because it is not me, and that car should not be involved in it because that car was sold to the scrapyard.
Gotcha. Okay.
Because if you don't, they're going to pull something, and it may fall back on you. So you at least, just say this is a real insurance company, and somebody else is acting like you. If they pay out that claim and they find out later that it's fraudulent, they probably may come after you. And whether you win or not, you're going to go through a whole bunch of BS before you win, and it's going to take up a bunch of your time when it shouldn't happen. Because you can let them know that there should not be a claim in your name. There should not be a claim involving that specific vehicle. And that vehicle was sold to the scrapyard, and the scrapyard is not supposed to be putting that car back out on the street. So if it was back out on the street and had an accident and the title was not changed over, still operating in my name, someone's actually in fact trying to claim that they are me in regards to submitting an insurance claim with you in order to get some money, is fraudulent. If you pay them out, they do it at your own risk. I'm telling you, it's not me, and I'm telling you that vehicle I sold to the scrapyard on this date, such. You need to be figuring out what's going on. I highly suggest you figure out what's going on because I'm under the impression that somebody is attempting to steal your identity and file a claim with an insurance company. If they was able to steal your identity and possibly get an idea in that, then if they call an insurance company and get a check issued, they'll be able to cash that check. Okay? And at the end of the day, you're going to be the one they come back after. Whether you win or not, they're going to come after you when you least expect it. You're going to have to fight it, and it's not worth it when you could cover your tracks now. And at least let the insurance company know that y'all need to investigate that because it shouldn't be going on. But before you do that, you need to figure out what exactly is going on.
Okay, so I'll just call and give them a claim number, but I'll tell them I'm not claiming anything. I didn't file a claim.
Okay, let me ask you. Okay, well, how can you give them a claim number then? If you never filed a claim, how would you know the claim number?
They sent it. The paper that they sent to my home had the VIN number on it, and they said it spoke something about a disposal of the vehicle. Well, why would I be filing insurance on a car that's no longer operable?
I don't know. Something's not adding up. So you know the claim number because they sent you something in the mail with a claim number on it.
Exactly.
Okay, and you never filed a claim.
No, I did not.
Okay, I mean, I don't see anything wrong with giving them the claim number. If you have the claim number, look, y'all tell me this ain't true. It has the claim number on it. I'll give you the claim number. We need to figure this out. You see what I'm saying? Because whoever you talk to, they're going to need it. If you call them, they're going to need that claim number to pull it up. It's good that they sent you a copy of something in the mail because you have a claim number to go off of. Once they pull it up,
Excuse me.
then they'll be able to tell you what they see. So I don't see, anything wrong with giving them the claim number to figure out what the hell is going on in regards to this issue. Because your name is tied to it, a vehicle with your name is tied to it. You need to get to the bottom of it before it comes back to bite you in one of your boots.
I'm gonna do that first thing in the morning.
Guy's an idiot.
Okay. All right. Anybody else got something they want to chime in on? You can press *8. Gilly, your mic is still unmuted.
Oh, what should do with this?
Trying to see what's in the chat. Give a shout out to I think there's the Jab 2006. BK Gillespie Stafford, how's it going? I think there's dude right out there, Mike Forby. I think I just came in and out.
Excuse me.
From that low frequency type of
Oh.
radio show. I'm not stupid. You guys think I'm retarded.
You are retarded.
Give a shout out to get 12, get 15, get 21, get 22.
Very stupid. You're very retarded, Tyre. That's why we love you.
Yes,
Endless entertainment.
We had West Oklahoma again, Southwest Florida. We got Kentucky on the line. We got another Southwest Florida. We got a West Michigan, another Southwest Florida. Also, we got Illinois. Speak to everybody that's out there in the chat and on the line. Got Southwest Florida with their hand up. They open their mic. Southwest Florida, you might be on mute. Southwest Florida. Southwest Florida, can you hear me?
Hey,
Mike?
yeah, I can hear you. Hey, what's going on, man? I just wanted to chime in. This is Squid, just hollering at y'all, been listening. And
I don't want to talk to
to
Squid. I don't want to talk to Squid. I want to talk to Dog, bro.
Oh, okay. Well, then how is everybody doing? Hey, hey, I'm enjoying the information, and I'm appreciating the fact that you are telling us to be a little more detailed and how important it is to grasp and conceptualize these words and phrases that we use, and understanding or understanding how important they are whenever you go into these venues to use words appropriately. So I appreciate y'all. I've been listening and enjoying the dialogue. The thing about
Thanks.
public notice,
Appreciate it.
I don't think a lot of people realize what actually is put in there and how important that public notice really is. So I'm just going to sit back and continue to enjoy the show. I just wanted to make sure I let you know I support the way that you support me. So keep doing what you're doing, man.
I appreciate that. We got us brother Greg House out there, for sure.
Just gonna go check on my laundry, start setting up my shower.
Show that goes on Tuesday evening. I have a link to that up on the live broadcast page on my website. Brother Sharif is on there as well. They both come on Tuesday. I'm gonna be doing some support and other people as well. So even though I'm creating this site, this straight exposure. I'll also be directing people to other people that are wholeheartedly supporting what they do. So, we can't try to hog up everything and be the only ones that act like we know something. Because if you ask me, I don't know. I just share what I feel like I what I understand. And I know I'm not the only one out here. And for anyone that keeps it straight 100 according to my rules, I'm willing to support and promote them and Brother Sharif as well as Brother Greg Dawes, or two individuals that I definitely support in what they do. You 75-25, you can't get on that list. You 75-25, you can't get no confirmation from me anymore. It's a wrap, because You know, the people are fed up, and it's about time that we wake up and we give them what's right instead of giving them something that basically puts Federal Reserve notes in our pocket. If we can't keep it straight 100, we don't need to be keeping. You know, we don't need to be, you know, at the forefront, you know, because it can cause a lot of people to harm and death. So, you know, I just always suggest people, you know, listen to, you know, pay key attention to what they say. And anything, you know, if you feel at any point that they contradict themselves, it's not, you know, bad to call in and question, because it may be that
Keep in
one
mind,
misspeak.
Tyra contradicts
But
himself.
when people are out here deliberately misspeaking, and you can comprehend that, then you know it's being done on purpose. So you have to have your antennas up and pay attention. So Brother Dawes gets into the Constitution and that child support issues and things. And I mean, he is very thorough. So I suggest people check him out again. I'll have his information up on my site shortly on the live broadcast. And about that public notice, people, we need to understand how we can use that to our advantage, but we also need to understand that it can also be used to our disadvantage. Because just like they use it, we can also. But just like we can use it against them, they in turn can use it against us. And I really should have put it the other way, because they use it against us first, and in turn, we can use it against them. So for those of you being blocked on, you know, filing documents into the county recorder's office, don't touch the toe off. Don't jump off the bridge and commit suicide. Read the rules of the game, because the rules of the game will tell you that public notice board in the courthouse serves as public notice. They will also tell you that an ad that is clearly described in the newspaper serves as public notice. Little do you know, you can create a Dropbox online, put your public notices in there or your documentation in there, get it notarized by a notary before you put it in there, self-authenticated, and then run an ad in the newspaper and give the link to where the information can be found, while saving yourself some money with a little bitty paragraph that addresses what the leads are, or addresses what the whatever you're attempting to do or put on the public record. Status correction in regards to such. I'll possibly be doing one this year claiming the name, and it'll be which I've already claimed the name, but I think I'm gonna run an ad in the newspaper to show some people another way that it can be done, and it's gonna be claiming all interest, which
Laundry's done.
It's recorded in the county recorder's office, so I don't need to run an ad in the paper, but I'm going to do it to show people how you can take and use that newspaper while not running the whole all your documents in the ad, because it'll cost you tens of thousands of dollars. A 15-page document is going to take up pages of the newspaper. Do you know how much money that's going to cost you? So you'll get to put like a little paragraph or something like that. Feasible, for your pocket. And you can run an ad in the newspaper, for instance, upper lowercase, whoever you are, is making a claim, putting a lien against and making a claim to, and it came in all capital letters as anyone, public or private, has something to do with the government, whatever, however you work, you know what I mean? And they want to see those documents, or they want to see their claim. Their claim can be found at the Dropbox folder of their school, whatever it may be. I'm going to tell y'all, man, it's not as hard as a lot of people making it out. Public notice is given the benefit. You can create your own form of public notice, even though they are blocking you from establishing public notice. Okay? So you have to figure out what is at your disposal. They can't stop you from posting notices on the bulletin board in the courthouse. And the rules in regard to each individual state clearly state that their public notice board serves as public notice. So if you put it on that board, certain people are assumed and presumed to have been notified. Now, in most cases, if may require you to also run an ad in the newspaper, notify for, a couple weeks, for a few weeks, depending on your state. You have to check that out. You may have to run an ad and let people know that you posted 15 notices, 15 copies. There's many copies down there on the public notice board in your county with the address, so on and so forth. It serves as public notice. So don't get all scared and mad and worried because you went to the county recorder's office and for some reason you allowed them to not allow you to file the documents into the public record because the county recorder's office is not your only form of public record. You know what I mean? I love recording things in the public record. I'm not going to let them restrict me from the public record access to filing. So I'm different than others. For some people, you have those powers. But at times of the essence, you have other avenues. It's what are you willing to do? What are you willing to sacrifice? If you're trying to accomplish something, you're going to have to sacrifice something, some time, some money. It may not be any money, but it may be time and energy. Or it may be energy and money, or it may be money, time, and energy. It depends on your specific issue. It may cause you to have to go out of finance or send off all these different certified notices, to pay for an ad in the newspaper, to record documents in the county recorder, to make copies. So don't sit up there and keep thinking everything is free. You cannot sit on your butt and get things done by crying and whining about it and not looking for additional remedies. There is not just only one remedy available to you in regards to each individual issue. There are multiple forms of a remedy that's available to you on every single issue that you have. You just have to do your due diligence and locate what remedies may possibly be available to you, and then be able to go through those remedies and see which ones best fit your needs or which ones are best suitable for you in your specific situation. We can't keep, sitting back whining. We have to, get up and make something happen. So I just want to say that it needs to get all into the public notice thing. But, I get a lot of people that, they can't get their documents recorded. First of all, you need to read the rules for recording documents in the recorder's office. And, a lot of you probably will realize that you created your own problem. You're the reason why they telling you that they can't record it because it's not legal. It's not in line with the rules. They're not going to tell you specifically. Your rules for your county record to record documents in your county recorder may say you're required to have a 1-inch margin all the way around the page. Well, if you put a footer and a header in the page, automatically by default, you're blocking yourself from being able to file that document into the public record by way of the county recorder. So you have to read the rules for recording depending on the specific document. Because the fact of the matter is, you are trying to get it into the public record so that there is a proper public notice given, right? So why not read the rules to know that if you're doing an affidavit, that it has to be notarized before an officer authorized to administer oaths, or they can file it into the affidavit file. Because an affidavit must be witnessed before an officer of the court authorized to administer oaths, and or a few witnesses according to the common law. So if you don't do either, and you just put together an affidavit, and you just put your signature on the bottom of it, so try to record it. Do you know that is in fact not an affidavit? Do you know it? You don't specify within that affidavit that affidavit is done based on is done on the by the best of your knowledge, and there's different ways you can word it that you put that affidavit together to the best of your knowledge. It is to the best of your knowledge and believed to be true, correct, and certain, and not misleading. That's what I was looking for. I couldn't think of it because there's many ways you can write. But for instance, it basically pretty much it falls under the Xerox. Like, I, true free man, knowingly and intentionally submit this affidavit. That's that is trying to add some things to it because you always can just switch it around. But it's pretty much you have to affirm that you're doing it to the best of your belief and knowledge, and that you believe it to be true, certain, and not incomplete, not misleading, and it has to be done under penalties of perjury. If you don't swear in or affirm, you can do either or both. It's not an honest. You cannot testify not being under oath. You cannot get on the stand and verbally testify and not be under oath. A lot of you don't understand when you go in court and you take the stand and you raise your right hand and you enter testimony on the record. Do you know that that is in fact a verbal affidavit? That testimony was taken before officers authorized to administer oath. Not only one, but many. Because the judge is the officer authorized to administer oath. The clerk is typing up the record is officer authorized to administer oath. And I'm for sure there's probably a couple more notaries in the courtroom as well. So affidavits can also be done verbally. But it has to be done on the record, the public record monitors, and it has to be done before witnesses, i.e. officers authorized to administer oath. And I hope that makes sense to you all. But the mics are open. I don't want to keep running my big mouth, but I tend to start talking to them fast, trying to rush out my thoughts because they come to me quick. But the mic is open for anybody that wants to chime in on the topic. I'll tell you what I'm going to do. I'm going to take about a minute break. Let me take a restroom break real quick. And I will be right back. If you want to chime in, you know, you're more than welcome to press star 8. I'll be glad to hear your questions, comments, and or concerns, anything that you may have to add or anything else that you may want to address while I'm on the line. Not going to be on much longer. We've got something else I got to take care of. Plus, I'm still playing around with this site. Just y'all check out my site. I'm going to put that information back in there again in case some of you that came in the chat are unable to review that. I'll post that information in again, but it's shredexposable.com. Matter of fact, yeah, I'll get there when I get back. Let me put on the tool real quick while I take a brief break, and I will come back and see what we got. See if there's anything. What do I want to hear? I want to hear some KB, not KB. I want to hear some. Let me hear a little bit less soul. Let's do this. I'll be right back. I appreciate you waiting. Congress is being bribed. The media is a lie. Entertainment got us controlled in this funky hard to survive. Every place in the currency is something called the America. They get concentration camps for you and everyone you oh yeah, that's no brother last song. You know, he got a couple out there. I just like those brothers that actually pretty much political rappers at this point, you know, in this day and time. Because, you know, a lot of people don't speak the truth and they don't speak what they speak. They're too scared, especially when you get into the musical industry. So, you know, a lot of you may not like rap because it's too bad, because of its powerful music as such. You know, I'm going to give it a spin. These are underground brothers, and I think they need more recognition than they are receiving, although they may never come on the mainstream because they're doing the total opposite as to what it you know, what it calls for them to do and rap about, to be part of the mainstream. So, you know, they have to have support as well. So, you know, it's just, you got to get people to start listening to it and paying attention and giving support. And maybe more people will do it. You know, but that's a whole nother topic within itself. But again, I'm promoting a lot of things on the website, and people can check that out. I see no hands up, so what I'm going to do, I think I'll click off of it. Let me pull back up my information. For those who may be in the chat, they may not have saw that. It's like funny how TalkShoe chat works. If you come in after things have already been posted, sometimes you're not able to see all the comments. So let me find, where is it? Let me, you know, my rules of the game. Y'all need to go check out my website. Really do. Fast and post all that information. Now, but check out my website, you know. Because people, you know, stating these specific rules of the game. You can't have rules of the game that you don't abide by. You see what I'm saying? I mean, that's just like ridiculous. You know, if you're going to state the rules of the game and expect people to abide by them, the least you could do is abide by them. You know, I ain't going to mention no one specifically, but rather paying attention, then you know, you comprehend clearly what it is. I just posted my email addresses. One is truefreeman at unseen.is, and of course you already know the other one, straight exposing them at gmail.com. I suggest you start emailing me at truefreeman at unseen.is. And I'll suggest you check that out and possibly create you an account. You may be happy with the privacy that you get over there and the encryption level of your messages being sent and or received. I just hope that you take out the time to at least check it out and give it a chance, and maybe you can help. Oh, copy I'm trying to paste. I'm posting I'm posting now the theme link where you can create your own account if you so choose to. You can follow me, you know, look up True Free Man and follow me on unseen.is, seen.is, and email me at seen.is. Unseen is the something like Facebook. There's also my secret GC, which is something that was created to basically counter YouTube and the blocking of information, videos, and things like that. So I have since created an account on Zeekly TV as well.
Zeekly TV.
My information is below. Because most of you already have my YouTube channel, but I'm going to post it again. YouTube channel link right there. I also have my new website, which is still under construction, but it's in progress every day. I
don't think he ever finished the goddamn website.
You see something there you want, or that may benefit you, or you want to want a consultation with True Free Man, those options are available. This is New Year 2015. I'm not sitting back and babysitting phone for you. You want personal time to compensate me for what I'm going to give to you, because I'm going to tell you, it's going to be the best time you've ever spent. Believe that we're talking to somebody. You know, because I have the questions and comments ready. If you're gonna, want to take consultation, I don't want you to run out your time. You don't think we get at the top of the hour or hours that you choose to get to receive, and I'm just going to cut you off at the drop of a dime, but we're going to wrap it up. But I'm more than willing to be a little bit flexible, and I don't mind talking to you. That's just what it is. I'm just not going to have a lot of my time taken up, and people just use me to acquire what they call.
Oh, Tyra, I'm using you right now.
So for those of you who want to support that, that's fine. Those of you who need that, that's fine. We terms and conditions as well, most definitely. And hope you enjoy the site. Before I log out, being hands up, I want to read my rules of the game. And I'll be starting off possibly my shows going over my rules of the game. I'm playing with some things right now. But if you go to my website on the first page, it'll say True Free Men's Rules of the Game. Then I have a slideshow that is registered. Okay? The rules of the game. Wow. You can see what I'm talking about. Rule number 1, keep it straight 100 at all times and never become 75-25. Well, rule number 2, remove the fear because a fear man can't and won't win.
A scared man can't and won't win.
Know the rules of the game that you are being forced to play. Rule number 4, play by the rules of the game that you are being forced to. All right, play through too fast. Rule number 4, play by the rules of the game and stop creating your own. Rule number 5, last but not least, if you want to be self-governing, act like it and stop asking for permission.
Self-governing, okay.
Just go through the site, check it out, tell me what you think. Got a home page, bottom page, live broadcast page, in which if you went on there right now, you can see that it is showing that True Free Man is live on TalkShoe right now. I have a pay-per-view page with previous webinars that I did and the upcoming webinars that will be in there. Webinars, classes, whatever you want to call it. I have a members-only section for paid subscribers, which there'll be a lot of videos that I'll do that won't be on Facebook. I'm not on Facebook. Won't be on YouTube or other formats, and the only way you'll be able to access certain things will be by being a member of the website. Have the Dropbox link if you want Dropbox access. Go to the website. People shouldn't have to ask you. You don't have to, flip through all my videos to figure out to find the link. Everything is going to be available to you on this website. And this is something I created from scratch within 2 weeks. Don't know what I'm doing, but it's going. It's looking good if you ask me. And I think it's going to work pretty fine for a lot of the things that people will need, and everything will be in one place pretty much as far as being able to get in contact with me, acquire whatever I have to offer, whatever that may be. I have a video page, I have a news page, a consultation page, so that you can click on that and see the different forms of consultation. And if that's something that you want to take advantage of, you're more than welcome. Something that you cannot afford or don't want to contribute to, hey, fine and dandy. Just, move on. Have the store page is still under construction. But it'll have the shirts, the we straight expose and decals for the car windows and things like that, and some other things. I'm be getting some mouse pads together with some of the things on the big mouse pads, and I'll be doing some videos showing some of the things that is to come in regards to the store. There's also a donate/gift page, which is packages with a gift. Regardless of what you do on my site, it will be for contributing. It will be in the form of a gift, and in some cases, it may be a gift. It may be a suggested gift that you expect in return based on the gift that you give. If you want to just give a gift just because you appreciate it and want to support the cause, which is what I do, and want to support the cause, you can do that. Other forms of gifts that you can give. You can gift to get a gift back of Dropbox access. You can gift to get a gift of status correction webinar and documentation. You can give a gift and get a gift in return for right to travel webinar and documentation and the remittance webinar and documentation. Those are if you give a gift, those are the categories in which if you give a gift, there is a suggested gift that you expect back in return for your gift. But I understand all gifts are not refundable. That's why it's called a gift. I'm just being upfront and honest. Have a terms and conditions page. I highly suggest you read that. That will pop up anytime you use the gift page or the gift link, the center link. The gift to get a gift in return, or just to send a gift just to be gift. You know, some of you will like it, some of you gonna have negative things to say, but hey, you say what you want. I'm out here doing, and I'm showing people, and I'm sharing with people, and I'm in fact helping people. I'm not gonna sit back and continue to get used and abused, and I'm not gonna continue to sit
Tyler,
back
we
and
use and abuse you every day. What's the problem?
I created my own website so I can host a lot of things on my website, so that I can block people from doing having access that I put out unless they contribute based on the fact that they take it and they put it on their shows and don't give credit as to where they got it from. So, with that said, that's why there's going to be a lot of videos. There's a lot of videos that I also already did and put on YouTube that I was just putting out there to the people. There's a lot of topics that I already supposed to went over to help people out, but I have not. I decided not to do that in that format based on the fact that the fees that's out there, and you know, being respect to where they got it from or who brought it to their attention, and the fact that they are conning people when in fact they don't really understand the information that they are attempting to give to you because they got it from someone else and hurried up and try to rush it out itself. So there'll be a lot of things that a lot of videos I'll be putting together that will not be on YouTube or Mazikli or anyone else, but they will be on the members only page or my website, which is for paid subscription. Okay, so you don't have to be a paid subscriber to look at a lot of information on my site, but there will be categories on my site in which only paid subscribers will have access to. So I told you guys I had plans in motion for 2015, and this is just only the beginning of it. I have a lot of things planned. There's a couple websites that I'm formatting right now. I have yet to buy those domains. I did buy this one in the web hosting, but I'm going to have about, I believe, like 8 websites total, and they're going to deal with separate, some different things. I'm not really going to get into that much because, you know, the gurus will hurry up and try to create a site and beat me so that when I create mine, they say I stole it from them. So I'm just when the sites get up,
like a kid.
Up, you will know. Also, I'm trying to, well, I'll leave that. There's quite a few things I'm doing. I just have to wait. I'm going to have to keep my big mouth shut and just get it done, and then bring it to the people. You know, and that's just what it is. You know, but I think a lot of people are going to be impressed. I think a lot of people are going to benefit from it. And I think it will allow me to do some things in a better way, so that people have access to a lot of different forms of the information that I have, as well as some other people that I will be pretty much supporting. Like I said, if you go to my live broadcast, there'll be a couple of additional people besides myself that if they go live, well, their information will be on that page. And if they ever go live, you can watch their show live on my show. Like on Tuesday, you know, you'll be able to check out Brother Greg Dodge. You'll be able to check out Brother Sharif. There's no telling who else shows that I support to the fullest, you know, that I'll put on there. I'll be doing some rotating of that. There'll also be some other people that I promote, like people doing their own thing for you know, making their own natural products and things like that. One, for instance, is the sister Micro Creations, and if you go to mycocreations.com, you can check her out. You know, she makes hoodies and clothing and different things like that. And people like that need the support. So, you know, I'm all about not only putting myself out there, I'm also out for exposing people to other people maybe they would not have access to if I had not put them up to, you know, up on them by way of acknowledging them on my site. So, you know, I just got a lot of things in the works, and it's not just about me, it's about us. And I think a lot of you may be, you know, happy with it, and a lot of you are not, because some of you, I'm ready to put y'all out of business. I ain't leaving no stones unturned. Do it how it needs to be done in the best way I can do it, and in the most professional way that I can do it. And while at the same time just trying to make sure that the people are understood and confident in it and are able to take something from it. And being that there are no hands up, I'll give y'all a couple of seconds. If someone has a last question,
Thank
comment,
God.
if not, I'll go ahead and find out. We've been rolling for a little over 3 hours. There's no sense going the whole 5 hours. And I have to get back into this site, try to work on I got something I got to take care of first. And I'll probably be up all night playing around with the site some more, getting my About Me page done. And I'm not even worried about the store right now. My About Me page, I got some more videos I need to drop in the video page at this point. And need to work on some things that I'll be putting in the members only category. There's nothing there now, but that'll be for anyone that basically just pays to subscribe, and which you don't have to, but you'll have access to information on my website that no one can get access to unless they pay to subscribe. So with that said, no hands up. It's True Free Man 317.
Thank you, Tyra.
Long call today. But I appreciate everybody taking the time out to give me an opportunity to be heard today. And with the exception of you, Troll.
We always gonna be here, Tyra.
Probably should be getting with you all on Monday for Straight Reality Monday. Gotta figure out what the topic of the call is, and I'm gonna basically put what the topic of the call is gonna be. And I'll put a little presentation together and try to get you guys a heads up on that. And hopefully it'll be something that may pique your interest, in which you may want to call in and comment and or just call in and listen to glean certain forms of information. May have a guest, who knows? We'll just have to see. I have to figure out what the topic is, and I may reach out to someone that comes in, and we may do a show together for Straight Reality Monday. Who knows?
No, I'm gonna do Straight Reality
Monday.
Monday.
With that said, I'm gonna go ahead and sign out. Appreciate y'all chiming in. Remember this Monday, Straight Reality Mondays, 6 p.m. Eastern Standard Time. Brother Sharif goes on at Brother Sharif goes on at 11 a.m. every Tuesday, Eastern Standard Time on Blog Talk Radio. Thor Radio, if you go to Blog Talk into a radio. And Brother Dobbs, I can't remember his, what you have to type in to get to his site. I always click on the link. But what I will be doing is he's on Tuesday evening. I think he goes on about 8 o'clock as well, 8 p.m. Eastern Standard Time, I think it is. But I'll have that information on the live broadcast page on my website. And I'll try to get that in here tonight, because my Talk Shoe is on there, my Ustream is in there, my live stream is in there. Then you have Brother Sharif's Blog Talk, and then under that I'll have Brother Dawson's Blog Talk as well. So you guys can click on those links and you can go check out their shows. And if you need some information from them or some help from them, those numbers are there. So it's a lot to come, people. So I appreciate it. I appreciate you all. Like I said, taking the time out to listen today and at least chime in and show a little bit of support. And I'll get to you all Monday, for Straight Reality Monday at 6 p.m. Eastern Standard Time on Talk Shoe. Same good show, same good channel. Unless I decide to go live this weekend on the spur of the moment. Y'all know how True Free Man is. He just do things off the, at the spur of the moment. So you never know. But if I don't, I'll catch up with you on Monday, and let me shut my big old mouth and close the show. And this is the True Free Man 317 signing out. I'm going to hold out with Teddy Reno while the show is ending. So for those who want to sit back and listen, you just go run one song going out. And I'm going to play Flight Letter to the Dog. I gotta get some new on here. But I'm gonna go ahead and go out with The Me You Don't See. And peace. Catch you all Monday. Straight Reality Monday, 6 p.m. Eastern Standard Time.
Thank you, Tyre. Free content. All right, thanks for coming by. I'm gonna stream more of this shit. Y'all know how it goes. Y'all have a good night. Fuck Tyre. Tyre intensive. Ooh wee. Good night.